Later, farming routes. What? You mean the later? But yes.
Says yes. You were containing the name.
Uh, Before we begin, a usual announcement by the Chief Justice. In the 75th year of its existence, the Supreme Court of India launches a small initiative which has the potential to have a big bang impact. WhatsApp Messengers is a ubiquitous service in our daily lives and has taken a role of a powerful communication tool to strengthen the right of access to justice and enhance transparency in the judicial system. The Supreme Court announces integration of WhatsApp messaging services with its IT services. Now, advocates on record, parties in person will receive automated messages regarding one, electronic filing, two, cause lists, and three, orders and judgments. The automated messages through WhatsApp will be received on successful filing of cases, notification about objections being marked by the registry in the cases filed, and registration of cases. All members of the bar and the registry officials will receive cause lists as and when published by the registry. In addition to accessing orders, judgments through the website, now all stakeholders, including members of the bar, will receive them on their mobile devices. The Supreme Court of India's official WABA number is 87676876676. There's a caveat. This number transmits one-way communication. In short, it is neither a callback nor reply back number. This facility and service will bring in a slight change or significant change in our daily work habits, but will go a long way in saving paper and our planet Earth. So we'll.
One more revolutionary step.
I hope everybody will even
One
judges
more
now we
revolution.
get the cause list on our cell phones. We don't have printed cause lists which I have sent to the judges in their offices anymore.
Oblate to your lordship.
Please, ma'am. Lord, Lord, just picking up from where we left off yesterday, Lord, I have prepared a short note because I did notice, my Lord, that much of what I said orally forced your Lordship to put it down in hand. So, my lord, I have taken the opportunity, a very short note, my lord, putting everything down. So it's by hand for your lordships, and your lordships don't have to.
Over the hard copy, or you?
I have circulated the soft copy with your lordships also.
Copy here, do
I'm not.
This one is volume. Note on the context of leading to the conclusion.
Yes, my lord. So, my lord, it's Roman 7 onwards.
All right.
Roman 7 onwards. And it's actually part of what I argued yesterday. I just want to show your lordship that I've recorded it in a note so that it's clear to you.
It's, yeah, exactly. Your pagination is in continuation with the earlier note.
It's in continuation. So, my lord, we've checked all of that, my lord, and I don't think your lordship will have any difficulty with that. And my lord, just as by way of, my lord, testing that out, if your lordship just sees note 7, but this is how I had tried to formulate the question for your lordships, and I've added 1 or 2 more thoughts to that. So, what that's at page 93.
That's one thing. Yes, now let's read the note.
Page 93, Lord, it's note Roman 7. Lord, I've actually formulated the question, Lord, if your lordships, Lord, find this acceptable. Lord, the issue in the present case, if all of your lordships.
Just let us
Please,
get our house
please,
in order.
please.
Not in order.
Please do. Please do. The only thing with the electronic record is that it's a little more difficult to navigate than paper. Lord, I have been a great proponent of the same, my lord. But the only thing is a little difficult to navigate, it's a little difficult to look at 2 things at once. Oh, that's what I find. Those are the 2 difficulties. Sorry, my lord.
Fingers at 5-6 places.
And my lord, yes, my lord, at great peril to the trees, my lord, it still remains a more convenient form. My lord. Yes. But a balance is a good idea, I find. My lord. What is bulky is here, what is not is here.
You can do everything now in the electronic form. So
Your lordship's, my lord, your lordship's example,
easier.
my lord, I hope is followed by every high court, my lord, because I am coming from a high court where we are struggling still with digitization.
it's all in the mind, actually. Judges just have to look at my colleagues, such senior colleagues, who are here in the
My lord, I am
Supreme Court.
full of admiration for your lordships, my lord. It's amazing. It's amazing.
One of the selling point of the Chief Justice is that if you use a digital device, you will, as you use more and more, you will look younger and younger.
But it has taken effect, my lord, evidently. But, my lord, not only that, my lord,
Incentive, my lord, that's the incentive.
but not only that, my lord, I, as a my lord, infrequent visitor to the Supreme Court, my lord, the transcription is brilliant. My lord, the video conference system is absolutely
Yesterday
brilliant.
you argued for such a long time post lunch.
But it is absolutely brilliant.
There was not even a moment where we felt we had lost the voice, or that we are not able to follow what you were saying.
Lord, it is absolutely brilliant. And because this is a national court and people have difficulty traveling to the court, the cost expense, Lord, it is a wonderful initiative. Lord, long may it continue.
That more and more lawyers from the High Court will have access to our digital courts, so that
It should be so, my lord. And I'm sure your lordships are aware, my lord, that in
remote areas also people coming from remote districts.
internet is available now almost everywhere. my lord.
Not just the significant constitutional cases, but simple cases involving citizens.
My lord, it's a remarkable movement forward.
In fact, what we have now done, I can share with you. I mean, for those who are tech geeks, that we are now we are migrating all our services into what is called the Meghraj Cloud 2.0, which is the cloud infrastructure created by the National Informatics Center.
My lord.
So we've already migrated most of the applications of the Supreme Court and of the e-courts project also. Almost 200 VMs have been migrated. So with the cloud infrastructure now, all courts can really go online. Earlier we had some limitations because of the capacity, but which all of us have now moved into the cloud infrastructure. And these are managed services. You don't have to maintain a building. You don't have to maintain, whole
Of course.
team of a cadre of technical personnel.
Of course, my lord.
It's all managed for you, and the data is all preserved on servers in India. So there's no problem of data going outside India or anything like that.
Not the only suggestion that I would make, because I know your lordship's at the forefront of this, not is uniformity. Your lordship system is so perfected. Lord, I wonder why other courts don't adopt the uniform system and the tribunals don't adopt it also.
In fact, I've got a matter
Sure.
where I've issued notice and
Well.
appointed, I think, 2 or 3 amicus, and that should come up probably once before we close for the vacation, just to monitor what the high courts have been doing. Some high courts, for instance, said if you want to have video conferencing links, you must tell us 48 hours in advance. Some high court said you can get a video conferencing link only if you are above the age of 60. So we had to pass a judicial order that what's this? Why you and the link should be in the cause list. Why should you apply 2 days in advance for a link? And why should we tell people that you will be only if you're a senior citizen you will get a link? It's agnostic to age. Technology has nothing to do with age. So we're monitoring it and passing some.
But I feel a few words from your lordship will iron out a lot of creases at the high court level, because of course my experience is actually at the high court level.
Also, it was, Mr. Art.39, it was a question of creating infrastructure. Now, what has happened, fortunately, was that government has sanctioned a budget of actually 7,000 crores for phase 3 of the e-courts project.
Madam.
And we've got the high courts also now on the e-courts project. And between November and now, 31st of March, we had to expend about 850 crores, which was the first tranche, which was meant that we're creating infrastructure for the high courts and the district judiciary. So high courts spent almost 94% of that amount. So hopefully with that now the infrastructure in the high courts will really be upgraded so that these problems which they faced in sort of having a robust IT infrastructure will now disappear completely.
I hope it all works out. It's a
Lord,
wonderful.
I have also taken instructions from the government so far as, my lord, our role is concerned. And there is a direction from the Honorable Prime Minister to give first priority to digitization, because access to justice to the common man is possible only when there is a digitization. He may not have to travel all the way to the High Court or to the tribunal, as my learned friend says, and he can access lawyers, local lawyers, those who are practicing in the district courts. So that's the priority of the government too.
Simple things like, for criminal trials, trials don't have to be adjourned because the IO is now posted or transferred elsewhere. So we are ensuring that, we'll have video conference equipment in the, not only in the district courts, but in the jails, enhancement of that equipment, in the forensic science laboratories, in the hospitals. So where medical evidence is to be given, why does the doctor have to come to
The court.
the court to prove a dying declaration? The doctor is there. I mean, and imagine what a loss of productive time for medical personnel who have to travel in large states to the center of the.
Well, I don't wish to go into that, but the new law also, my lord, takes care of that. My lord, that electronic evidence, my lord, would be electronic in the sense that a deposition given electronically would be treated as an evidence, valid evidence.
We're moving very rapidly by pushing the high courts to upgrade their infrastructure. And the financial backing is there. I mean, otherwise, what happens is there are state governments who are good with finances. Other state governments don't give even a farthing to the judiciary for IT and so it's now money goes straight from the government of India through the committee of the Supreme Court to the High Court. So there's no issue of of the money not being actually allocated by the state governments.
No, it has been a huge, huge improvement, my lord, with regard to the access to justice also for many, many people.
Yes,
Lord, if your lordships
see
all
what you
have the note now, my lord. My lord, I have just formulated the question, my lord, if it pleases your lordship to look at this, my lord. The issue in the, do all of your lordships have the note? Yes. My lord, the issue in the present case specifically concerns the constituent power to vary a provision of the Constitution by substituting existing language by new language. The issue is the effect of the court declaring a substituted provision of the Constitution and or the Constitution Amendment Act, bringing about the substitution unconstitutional on the ground that it is beyond constituent power of Parliament to amend the Constitution. Lord, forgive me for using the technical language, but I thought to formulate before your lordships, but we should use the correct technical language with regard to constituent power. Lord, briefly stated, Lord, what happens when the court declares a substituted provision to be unconstitutional? That is the question which presents itself before your lordships. Lord, I've just illustrated the three types of legislative constituent activity, Lord, by extracting 368 for your Lordship's consideration. Lord, power of Parliament to amend the Constitution and procedure. Notwithstanding anything in this Constitution, Parliament may exercise its constituent power. How? Lord, in three ways: by way of addition, by way of variation, or repeal any provision of this Constitution in accordance with the procedure laid down in this article. So, Lord, there are three types of constituent activity, Lord, which is provided for: addition, variation, and repeal. Lord, Article 368(1) provides for Parliament's constituent power to amend by addition, variation, or repeal. Variation can be in many forms, including by way of substitution. So, Lord, variation is a little different as I see it from substitution. It may include deletion as well, but it could include substitution. Lord, the effect of the declaration of unconstitutionality on a substituted provision is different from the effect of such a declaration on either an addition or a repeal. Lord, I've dealt with that in a separate note, so I've referenced it. And the effect of Parliament itself repealing a constitutional provision or a part of the constitutional provision is also different from a declaration of unconstitutionality by a court of a constitutional provision. So, my Lord, I will, Lord, a little later address your Lordship, my Lord, very briefly on what is the effect of your Lordship's declaration of unconstitutionality. Not briefly stated, not it doesn't actually remove the provision from the statute book, but it renders it void, as I will show your Lordship. And it has a peculiar effect, my Lord, on a substituted provision. So, my Lord, this is just to frame the question before your Lordship. Lord, I just want to, Lord, pick up on one thing I had said yesterday to your Lordships, my Lord. And I wonder if I was too fast in going through that. Lord, we've already witnessed in the context of 31C, well, Lord, these three activities, or at least two of the three activities. Lord, the 20th April 1972 insertion by the 25th Amendment Act was a legislative addition. So, Lord, that falls into the addition part of 368. Lord, the 18th December 76 42nd Amendment was a substitution, which is what.
Can you just tell us again?
Sorry, Mal. Lord, the three types of legislative activity are actually demonstrated through.
Addition, variation, or repeal.
Right.
That's right.
So, my Lord,
The
20th
dates which you were
April,
giving.
20th April 72 was the 25th Amendment addition of Article 31C. Now, my Lord, on 18th December 76, we have a substitution, my Lord, of the narrow language with the broader language, what brought about by the 42nd Amendment. And, my Lord, on 30th August 79, your Lordship will recall that movement through the Lok Sabha and the Rajya Sabha, not by the 44th Amendment. My Lord, we have a deletion, which was the deletion of Article 31. Rest of it didn't go through. So, my Lord, we've already seen, my Lord, in this brief period with regard to Article 31C itself, my Lord, these various type of legislative activities. My Lord, I've just also, my Lord, done this analysis for your Lordship, if it helps your Lordship, to give your Lordship 5 dates of the relevant orders. Lord, 9th May 1980 are the orders in Vaman Rao and Minerva. Lord, 31st July 1980 is the Minerva judgment. 13th, sorry.
Yes.
13th November 1980 is the Vaman Rao judgment. And actually on the same day again, my Lord, we have a coincidence of same days. On 13th November 1980 is also the Bhimji Sen judgment. Yes. And, my Lord, we have two other judgments. My Lord, on 10th December 1982, we have Sanjeev Kok. And on 13th March 86, we have the Basanti judgment. Oh, your Lordship will find all of this, my Lord, in my legislative history, but just by way of, in summary form, not in a nutshell. But this is how the important dates lie.
Now, Minerva on 31st July 1980, actually
Yes.
9th May 1980, it strikes down 31C as expanded by the 42nd Amendment.
Yes, Lord.
But, right? But then Vaman Rao holds that the unamended Article 31C is valid because it was validated, it was declared to be constitutional in Keshwan and Bharati.
For that and for
Vaman Rao,
another
the
reason.
judgment in Vaman Rao is on 13th November 1980.
Yes, Lord.
Which is after the recent judgment in Minerva is pronounced on 31st of July 1980. So conscious of the fact that Minerva had been pronounced in terms of its reasons on 31st July 80, in Vaman Rao, the court still comes to the conclusion that 31C, pre-amended by the 42nd Amendment, is valid because it has been held to be valid by. Now, we must add one more factor to it, which is that once 31C was held to be valid in its unamended form prior to the 42nd Amendment in Keshwan and Bharati, except for that declaration, which we'll ignore for a moment, Minerva was not, therefore, couldn't have done something to the contrary. For the reason, and as they rightly say in that paragraph, not only did Mr. Palkiwela make that concession, but they said it was rightly made and correctly made. So what we then have emerging is this, that the pre-amended 31C is valid. The post-amendment 31C, expanding the ambit of 31C to include all the directive principles, has been invalidated.
Perfect. So perfect assessment. And I must grapple with the problem posed by your lordship, Lord, at the close of yesterday and what your lordship has articulated today, which is what I've spent Lord, the time that I had between
So
yesterday and
does, in a
today.
factual situation like this, does the pre-amended 31C get obliterated merely by virtue of the fact that post-amendment, the pre-amended words of 31C were sought to be expanded, and that part was held to be unconstitutional?
That is the question viewed from the other side.
That's the point which we have to answer. So how do you address
No,
that?
my lord, I address that not principally through Vaman Rao. And that is why I take your lordship immediately
Let's
to
see what
note
you
8.
say on Vaman Rao now.
Yes, my lord. So, my lord, I would like to take your lordship through Vaman Rao. But shall I first
Let's your note actually.
note, but because I've summarized everything because the judgment is so long.
Because
But
Vaman Rao, there are 4 paragraphs, 50,
Exactly.
53, 54, 55.
well, I've extracted all of that also. So, my
Then
lord,
we'll see.
just
from
come to
there.
my note.
Yes.
But let me show your lordship the note and then I'll show your lordship the conclusions which I have drawn.
No problem.
So, my lord, page 94 for your lordships.
What?
Lord, page 94, if all of your lordships have it.
Yes.
Lord, if your lordships will note, Lord, this was a judgment which was delivered, my lord, by 5 judges. Lord, the judgment involved a challenge to the Maharashtra Agricultural Land Sealing and Holding Act, number 27 of 61, and the amendments thereto. Vide several amendment acts, collectively referred to as the 61 Act, which was brought into operation from 26 January 62. The validity of the act was challenged in 2660 petitions before the Bombay High Court. Not I'm getting all these events from the majority judgment, recitation of rights. By a judgment dated 13th August 1976, a division bench of the High Court of Bombay, sitting at Nagpur, repelled the challenge in Vitthal Rao's case. The division bench held inter alia that the 1961 Act and the amendments thereto were not open to challenge on the ground that they were inconsistent with or took away or breached any of the rights conferred by Part 3 of the Constitution, since the acts have been placed in the 9th schedule by the Constitution of Amendment 17th Amendment Act and the Constitution 40th Amendment Act 1976. Further, on the ground that because of the promulgation of the emergency, the rights under Article 14 and 19 of the Constitution could not be enforced, the High Court also repelled the challenge to the validity of 31B itself on the grounds stated therein. But the High Court actually said 31B furthers the principle of the directive principles of state policy. But appeals were then filed against the decision of the Bombay High Court. Lord, the cause title there was Dattaraya Govind Mahajan. By a judgment dated 27 January, the Honorable High Court dismissed, this Honorable Court, the Supreme Court dismissed the same. Upon revocation of the proclamation of emergency, petitions were filed by the appellants praying for a review of the judgment in Dattaraya Mahajan's case. Inter alia on the grounds that the emergency had suspended several of their fundamental rights and grounds, which were otherwise open to them and could not be made by reason of the emergency. Some other fresh petitions were also filed in the Honorable Supreme Court. Accordingly, the matter came to be considered by the Honorable Supreme Court. The majority judgment delivered by Chief Justice Chandrachud for himself and Justice Krishna Iyer, Tulsapurkar and AP Sen recorded the challenge before it in the following terms. Now, Lord, I've extracted this. In these proceedings, so Lord, this was a direct challenge, is what I want to show you, Lordship. Lord, to 31A, 31B, and 31C. In these proceedings, the main challenge now is to the constitutionality of Articles 31A, 31B, and unamended 31C of the Constitution. The various grounds of challenge to the Principal Act and the amending acts were met on behalf of the respondents by relying on the provisions of these articles, which throw a protective cloak around the laws of certain description and variety by excluding challenge thereto on the ground that they were violative of certain articles of the Constitution. The reply of the appellants and the petitioners to the defense of the respondents is, as it could only be, that the very provisions of the Constitution on which the respondent relied for saving the impugned laws are invalid, since these particular provisions of the Constitution, which were introduced by later amendments, damage or destroy the basic structure of the Constitution within the meaning of the ratio of the majority judgment in Kesavanand Bharati. So, the challenge was a straightforward, basic structure challenge as far as we are concerned to 31C. From the above, it is evident that the challenge as far as Article 31C is concerned was to unamended Article 31C. It is also relevant to note that the judgment which had recently been delivered, this is to my Lord the Chief Justice's point, in Minerva Mills was also expressly noted by Chief Justice Chandrachud in paragraph 9 and 15, but I've given the references to your Lordship there. In paragraph 9, the judgment was noted with regard to section 55 of the Constitution 42nd Amendment Act, amending Article 368, and in paragraph 15 it was noted that Minerva Mills struck down section 4 of the Constitution 42nd Amendment Act. The challenge with regard to 31C was considered and dealt with in paragraph 52 to 54. As your Lordship says, there are only two really relevant paragraphs. That leaves for consideration the challenge to the constitutional validity of the unamended Article 31C. As we have stated at the beginning of the judgment, Article 31C was introduced by the Constitution 25th Amendment Act 71. Initially, it sought to give protection to those laws only, which gave effect to the policy of the state towards securing the principles specified in clauses B and C of Article 39 of the Constitution. No such law could be deemed to be void on the ground that it is inconsistent with or takes away or abridges the rights conferred by Article 14, 19, and 31, the concluding portion of the unamended article, which gave conclusiveness to certain declarations was struck down in Kesavanand Bharati. 54. So, my lord, my lord, one plank of the reasoning was Keshavanand Bharati. Now, my lord, the second. Apart from this, so my lord, in addition to that, if we are right in upholding the validity of Article 31A on its own merits, it must follow logically that the unamended Article 31C is also valid. So, my lord, this was on parity of reasoning between 31A and 31C. The unamended portion of 31C is not like an uncharted sea. It gives protection to a defined and limited category of laws which are passed for giving effect to the policy of the state towards securing the principles specified in Clause B and C of Article 39. These clauses of Article 39 contain directive principles which are vital to the well-being of the country and the welfare of its people. Whatever we have said in respect of the defined category of laws envisaged by Article 31A must hold good, perhaps with greater force, in respect of laws passed for the purpose of giving effect to Clause B and C of Article 39. It is impossible to conceive that any law passed for such purpose can at all violate Article 14 and Article 19. My lord, it's sentiment expressed, my lord, the Chief Justice yesterday as well. Article 31 is now out of harm's way. In fact, far from damaging the basic structure of the Constitution, laws passed truly and bona fide for giving effect to the directive principles contained in clauses B and C of 39 will fortify the structure. We do hope that Parliament will utilize to the maximum its potential to pass laws genuinely and truly related to the principles contained in clause B and C of Article 39. The challenge made to the validity of the first part of unamended 31C therefore fails. Or just by way of summary. So, not two grounds. Not one is Kesavananda Bharati has already upheld it. But the second independent ground is that if we uphold 31A, agrarian reform, and other such similar laws, then surely on parity of reasoning, we must also uphold 31C. And Lord, the very important observation which I'll come to later on, Lord, where the learned Chief Justice says that how could a challenge based on 14 and 19 succeed against a law which is truly towards the purpose of 39 B and C? Not something which my Lord Justice Dhulia sort of echoed in the example and the discussion on 39B as well. If it's truly towards alleviating inequality, what is your possible challenge under 14 and
39 with 38.
38? Sorry.
And in this, the reasoning is given that it gives protection to a defined and limited category of laws which are passed for giving effect to the policy of the state towards securing the principles specified in clause B and C of Article 39. So because it is specific,
And limited.
it is not the entire directive principle. Therefore, it is valid.
Your Lordship is perfectly correct.
It is not just because 31A and 31B have been upheld, therefore we are doing it.
No, but I would
Another
agree.
reason is this.
No, your Lordship is correct, but perhaps.
B and C, to that extent, fine. If you take the entire directive principles, no. That's
But for a specified purpose, namely
specified purpose is 39A, B and C.
B and C, Lord, it passes muster. So, Lord, independent reasoning. But that's what I wanted to impress upon your Lordship. Not only Kesavananda Bharati, but independent reasoning. But some may say, so far.
Look at the language, just the sentence after that.
Please, my Lord.
It gives protection, as my brother just now read out.
My Lord.
Protection to a defined and limited category of laws which are passed to give effect to the policy of the state towards securing the principles specified in Clause B and Clause C of Article 39.
My Lord.
And these clauses of Article 39 contains directive principles which are vital to the well-being of the country and the welfare of the people. Just look at the brilliance of the articulation.
There is no
It is
doubt
lovely,
about that.
unmatchable, actually.
Or I would say one thing, my Lord, that or I said it the other day also, my Lord. This was an age of masterful writing, my Lord. And my Lord, in particular, my Lord, some of these judgments. My Lord. But the bar was set very, very high for all of your Lordships, my Lord. My Lord, I've my Lord, attempted an analysis, my Lord, in Roman 5 and 6. My Lord, from the concluding part of paragraph 53, it is clear that Article 31C was inter alia upheld on the basis of the ratio of the majority judgments in Keshav Nanda Bharati. However, the fact that this was not the only basis is also evident from paragraph 54, which by its lucid reasoning provides inter alia that Article 31C gives protection to a defined and limited category of laws. To both of your lordship's point, the lucidity as well as the limited nature of 39C. Pass for giving effect to the policy of state towards securing the principles specified in clause B and C of Article 39. That Article 39 was vital to the well-being and to the welfare of its people, and whatever was said earlier in the judgment with respect to defined category of laws envisaged by Article 31A must hold good perhaps with greater force in respect of laws passed for the purpose of giving effect to B and C of Article 39. The learned, I should say the Chief Justice, I'm sorry, went on to state that it was impossible to conceive that any law passed for such purpose could violate 14 and 19. Lord, in paragraph 55, the judgment also clarified. This is a very interesting clarification, actually, Lord. And Lord, it actually occurred to me, Lord, it has great bearing on the Colio point, but Lord, I'll leave that for now. Lord, in paragraph 55, the judgment also clarified that the individual examination of laws, Lord, I've not extracted it, perhaps I can read it to your lordship. The individual examination of laws inserted into the ninth schedule on or after 1973, which provided for earlier in the judgment against the basic structure of the Constitution, would become ocious if such laws fell within the scope of 31A or the unamended Article 31C. And accordingly, it would become unnecessary to determine whether they receive the protection of Article 31B read with the ninth schedule. So, Lord, what the learned judge said was this, Lord, that you don't need to check whether the law which is inserted into the ninth schedule is violative of 14 and 19 if it is already covered by Article 31A and by Article 31C. So, Lord, some powerful reasoning, my Lord, with regard to 31C. Now, Lord, I've only mentioned overleaf. My Lord, just as a matter of fact that there was a dissent in that judgment. My Lord, Justice Bhagwati, after delivering a dissenting judgment and Lord, Justice Bhagwati, delivering a dissenting judgment and reiterated that he had already given his reasons for subscribing to the order delivered earlier in his dissenting judgment in Minerva Mills, and that the same should be treated as forming a part of the present judgment. He expressly identified various portions of Minerva Mills' judgment as the reasons for making the order of 9th May 80 in the present case. Now, my Lord, since it's a dissent, my Lord, and in the interest of economy of time, Lord, we need not go into it, my Lord. So, my Lord, it doesn't have any legal effect. Now, my Lord, my comment on Vaman Rao is as follows, my Lord, and my Lord, this may be taken as my submission on it, my Lord. Comment on Vaman Rao in relation to whether it can be regarded as having decided the question of revival of unamended Article 31C. Vaman Rao was concerned with the question of validity of the unamended Article 31C. In Vaman Rao, the Act of 1961 was being challenged, inter alia on the basis described in the judgment above. As is evident from what is stated above, the challenge in all proceedings before the Bombay High Court and the Supreme Court were in respect of matters prior to the 42nd Amendment Act taking effect on 3rd January 1977. So, my Lord, in terms of temporal analysis, it was all before this amendment took effect. It is submitted that paragraph 3 of the order of the court dated 9th May 80, which held Article 31C unamended, is valid to the extent to which its constitutionality was upheld in Kesav Nanda Bharati and does not damage any of the basic or essential features of the Constitution or its basic structure. I paraphrase the order. Must necessarily be understood in respect to the challenge and grievances which were raised in the proceedings before the Supreme Court. But this is how I have tried to deal with it now, Malone. But it is well settled that judgments must be read as judgments in the facts of the case and not in abstract. The principle applies to judgments on constitutional law as well. It is further submitted that the judgment in Vaman Rao must be understood in the context of the constitutional challenge that was made there, i.e., a challenge that the unamended Article 31C was in breach of the basic and essential features of the Constitution and stroke or the basic structure. This was the only challenge which was repelled, and the declaration of validity of unamended Article 31C in the judgment must be understood in this context. Not overly. It is submitted that a Constitution Amendment Act or an article of the Constitution may be held to be valid against a particular challenge by repelling that challenge, but unconstitutional on another challenge by accepting the grounds of the other challenge. The mere fact that the constitutional provision is held to be valid by repelling a particular challenge does not confer upon it a constitutional validity in perpetuity, which safeguards it against future challenges of a different nature.
You have to elaborate on this. What are you trying to say in this?
Madam.
6.
Yes, madam.
Submitted that a
Constitutional.
But may I read it again, madam? But this is my proposition to your lordships, madam. But I'll try to elaborate it a little further, my lord. May I just go through the note and then deal with it extempore, my lord, with your lordship? I'll try to actually deal with it further, because this is the nub of my argument to your lordships. Illustratively, to my Lord Justice Dhulia's point, this is how I've tried to explain it, because I understand, my lord, that this requires some elaboration. It is entirely possible that a constitutional provision may be held valid against a challenge under Article 19 by repelling that challenge, and yet subsequently be held unconstitutional against a challenge under Article 14 or 21. It is an admitted position and evident from the record that the Honorable Supreme Court in Vaman Rao did not consider the validity of unamended Article 31C on account of the judgment in Minerva Mills holding Section 4 of the Constitutional Amendment Act unconstitutional, on the ground that it damaged the basic structure of the Constitution. So, Lord, this issue of revival was not present to the judges in Vaman Rao at all. It is also evident from the record that Chief Justice Chandrachud, for the majority, repelled the challenge and upheld the validity of unamended Article 31C solely on the grounds stated in paragraph 53 and 54. As such, now, Lord, this is my conclusion. Vaman Rao has no precedential value whatsoever with regard to the present issue, and in fact, as from what is stated above, demonstrates that the challenge was on an entirely different basis. So, my lord, this is my attempt to grapple with the problem which your lordships presented to me yesterday. Now, my lord, just a few comments on this, my lord. So, my lord, stepping away from Vaman Rao, etc., just as a general principle of constitutional law, my lord, a constitutional provision may be challenged on various grounds. But just illustratively, I've given your lordship an example of 19, 14, and 21. My lord, conceptually, my lord, I don't think, my lord, I could be said to be wrong, my lord, to conclude that one might succeed, another might fail. Lord, when one fails, or let us say an Article 19 challenge, Lord, the statement of validity by repelling that challenge is just that. It is to say that it is valid against that challenge, but not to say that it remains valid against other potential future challenges. So, my lord, I, for one, my lord, see little difficulty in accepting the conceptual position that a article which survives a 19 challenge may fall to a 14 challenge. Lord, there is another more elaborate aspect to this also. Lord, if we accept what is undoubtedly true, my lord, that our constitution is a living document and that our constitutional values change with time, Lord, it is entirely possible that a challenge made under a particular article of the Constitution, say 14, might fail in 1976, but may succeed in 2024. I'm not the leading example, of
But
course.
then we have to reconsider that judgment.
Your Lordship may have to, and therefore I come to that point that I am free of that difficulty because I'm before 9 of your Lordships. And those were 5. Yes, my Lord, it is entirely possible. It may require a comment on that judgment.
But we are again subservient to a decision of 13.
Yes.
I have something to, yes, no, your Lordship is right. So that Keshav Nanda problem, my Lord, is a problem. My Lord,
You know, if both Minerva and Vamanrao particularly was just based on a judgment of 5, of course we could have reconsidered it. But today Vamanrao admittedly says that the validity of 31C, the unamended 31C, has been upheld in Keshwanand.
no, my Lord,
That stares us in the face. So the only point then which we have to consider is this, that since Minerva struck down the entirety of Section 4 of the 42nd Amendment, which included 39B and C as well.
but that is a later part of my argument.
Yes.
Yes.
Does that part relating to 39B and C get revived? That's the only point.
Your Lordship is right.
Because reconsidering reconsidering now Vamanrao, that will not really
No,
arise because Vamanrao in turn follows, though of course they've given additional reasons, but it follows Keshwanand. And irrespective of the additional reasons in Vamanrao, we are bound by Keshwanand.
Lord, I accept what your Lordship says, and I didn't think your Lordship would say anything to the contrary. Lord, just by way of an interesting aside, my Lord, one of the judgments, Lord, it has a fascinating analysis of the doctrine of precedent. This is not quite the precedential point, but it speaks about how the Normans always regard the older law as the better law. If I'm not wrong, my Lord, once again, it's Justice Chandrachud's judgment.
But Mr. Andelshna, you are right that a constitutional provision which has been upheld against a challenge on one particular constitutional ground, the validity of that constitutional provision can be considered by the Supreme Court itself.
Of course.
On other grounds, Ali and Day. High courts can't do it.
Exactly.
The Supreme Court has upheld the constitutional validity under 19. High courts cannot say that, well, 14 was not considered for another reason as well, that 19 and 14 are now no longer treated as silos. They all amalgamate with each other. And after post Cooper and
Maneka Gandhi, they all bleed into each other. Your Lordship is right.
Supreme Court can certainly say that, well, in that case, the challenge was on the ground of legislative competence. We look at the fundamental rights challenge here. Second, a provision which is constitutional and that applies to a legislative provision on the date when it was enacted may cease to become constitutional later on, which was the principle laid down in Motor General Traders by Justice Venkatramaya as the Lordship then was, and followed in Malpe.
My Lord.
Right, and that's how Malpe said that, look, this provision was valid when it was enacted in the Bombay Rents Act in 1947, but no longer valid now. Those two issues do arise. But now, we really, the narrow issue which we have to consider is this. What is the effect of the declaration of Section 4 of the 42nd Amendment as unconstitutional? Will that, in that sense, affect the operation of the unamended Article 31C? Your point really is this, that unamended Article 31C was confined to 39B and C. That was subsumed in the expansion. The entirety of the expansion is struck down. So where is the question of revival? To which possibly the answer would be that, look, the reasoning in Minerva, in that paragraph, which you come to in a later part of your note, I was actually preempting you because I was reading ahead of you. Before we begin, in Minerva, usual announcement by the Chief Justice, not in relation to the 75th year of its existence, the Supreme Court of India launches a small initiative. That discussion in Minerva has the potential to have about this big bang wide expanse now, which has WhatsApp messengers, all provisions. If a service in our daily lives and has taken a role of a powerful communication tool it's immune to strengthen the right of access to justice and enhance transparency in the judicial system. The Supreme Court announces integration of WhatsApp messaging services with its IT services. Now, advocates on record, parties in person will receive automated messages regarding one, electronic filing, two, cause lists, and three, orders and judgments. Because it was one omnibus judgments. The automated messages through WhatsApp will be received on successful filing of cases. Notification about objections being marked by the registry in the cases filed and registration of cases.
It's arguable either way.
All members of the bar and the
always
registry
arguable either
officials
way.
will receive cause lists as and when published by the registry. In addition to accessing orders, judgments through the website, Now, all
that do we say
stakeholders,
that, look,
including
now
members of the bar,
31
will
in its
receive them on their
entirety is
mobile
But let me
devices.
effaced?
show your
The
lordship
Supreme
there
Court of
the
India's
constitutional
official
principles with
number
regard to
is
the declaration of
87676,
unconstitutionality and on
87676.
effect on
Now,
substitution.
you
That's a
have
separate.
finished your Vaman Rao
I
part.
finished with
Transmits
Vaman Rao.
one-way
I take your
communication.
lordship.
Minerva, because then,
Let's
then
Minerva
we
Neither
can
a
go into the
callback
heart of
nor
the
a
matter.
flyback
You know,
number.
Straight away.
I don't
This
think
facility and
Now, while
service will
Minerva
bring in a
also I
slight
tried
change,
a
a
lot
significant
to
change
do
in
a
our
little bit
daily
of
work
extraction
habits.
for your lordship's
It will
convenience.
go a
Yeah,
long
actually,
way in
that's good
saving
because,
paper
that's
and our
really the
planet.
relevant part.
So, my lord,
one
this
more
is page
revolutionary
99
step.
on
I
that.
hope, everybody
The
will,
fact remains,
even
One
judges
more
now
revolution.
get the
Vaman Rao,
pause
whatever
list
has been
on our
stated,
cell phone.
is
We don't have
subsequent to the
printed pause lists
judgment
which
in
I have
Millar Moments.
sent to the judges in their
That is
offices
true.
anymore.
Challenge is to a stage anterior to
Obliged to
Millar
lordship.
Moments. The bench is conscious of what they have stated in.
No, my lady is right. That is a difficulty in my way, but I'm trying to deal with it.
Stated.
Yes. That is actually the problem for me, which
just
I'm trying
picking
to
up
grapple
from
with where we left off yesterday. Lord, I have prepared a short note because
Yes,
I did
just see
notice,
para
my lord,
58
that
at,
much of what I
internal
said
page
orally
10 of your
forced your
note.
lordship to put it down in hand. So, my lord, I have taken the opportunity, a very short note, but can I come back everything down? So it's by hand for your lordship. I want to deal with that concession point also to my Lord Justice Rishikesh Roy's point. I have circulated a soft copy with your
But you know,
lordships
the
also.
thing is, that concession now, I think
Very well.
it's pretty
I'm
clear.
not very-
But they say Mr. Palkhiwala conceded that the unamended Article 31
This one is volume.
valid.
Note on the
He could not
context
have
of
done so
leading to the
otherwise.
conclusion.
Yes,
And
Lord. So, my lord,
rightly
it's
so.
Roman
Because of then
7
they refer to
onwards.
Keshwan.
Well, I am content Roman 7. And it's actually part of what I argued yesterday. I just want to show your lordship that I've recorded it in a note. It is in so that it's clear to you. That the validity of amended Article 31C has to be examined.
Just one second,
Please.
Page 10.
Your pagination is
Page,
in continuation with the earlier note.
101.
It's
in continuation. Fine. So, my lord, we've checked all of that, my lord, and I don't think your lordship will have
And
any
para
difficulty with that.
801.
And my lord, just as by way of my lord, testing that out, if your lordship just sees note 7, but this is how I had tried to formulate the question for your lordships, and I've added 1 or 2 more thoughts to that. So, what that's at page 93. And this problem of pagination is it's a perennial problem. I've been trying to solve it myself, but there's something called Bates numbering, my lord, which actually links it with the way that it is numbered in hand. I've not yet been able to solve it entirely. Page 93.
I tell you now, that
Lord,
I don't want to break
it's
the flow
note
of your
Roman
argument.
7.
This is a perpetual
Lord,
problem.
I've actually
now
formulated
we have
your
electronic
question.
files
Lord,
with the
if
Supreme
your
Court.
lordships, Lord, find this
What we are
acceptable.
doing, what we find is that
Lord,
the page
the
with the
issue
lawyer's
in the
side
present,
of the
if all of your
electronic file
lordships,
is not the same
please,
as our
please,
page.
please,
So I
please,
said,
Not in
there is
order.
a
please, do.
technological problem.
No, but
We
there's
think
a-
in technology can be resolved.
The only
we've
thing with
resolved
the
it.
electronic
The only thing it
record
requires a
is
little
that it's a
discipline on the
little
part of the
more
lawyer.
difficult to
That's how you
navigate
arrange
than
what
paper.
happens is,
Lord,
the
I have been a
moment,
great
say, an
proponent
office
of the
report
same,
comes,
Lord.
we have
But the only
our
thing is a little
digital
difficult to
files are
navigate, it's a
divided
little
into 3
difficult to look at
segments.
2 things at once. Oh, that's what I
Volume
find.
1
Those are the 2
is the original paper book.
Well,
Volume 2 is what we call the
Sorry,
additional
Madam.
paper book, which will contain the
Fingers and
rejoinders,
pipes
the counters, rejoinders,
and
interim application.
Lord, yes, my
Volume
Lord, at
3
great peril
is
to the
the
trees,
record
Lord,
of
it still
proceedings.
remains a more convenient form.
Now,
Lord.
when a new pleading is filed
But a
in
balance
volume
is a
2,
good idea, I find.
the
What is
pagination
bulky
of
is
volume
here,
2 will
what is
change.
not is here.
When a new office
You can do
report comes
everything
and
now in the
pagination of
electronic
volume 3 will change.
So
Your lordship's,
Email it to
Lord,
the
your
lawyers
lordship's example,
automatically. They
Lord,
don't
I
have to
hope
download
is
it.
followed by
It sits
every
in the
high court, Lord,
lawyer's,
because I am coming
inbox.
from a high court where we are
The
struggling
trouble
still
is,
with digitization.
advocates on record, when
it's
they
all in
brief
the
seniors,
mind
don't
actually.
take the,
Judges just have
they
to look
don't
at
take
my
the trouble of,
colleagues, such
looking at
senior
the,
colleagues,
at
who
the
were
latest
here in the
uploaded.
Lord, I am
Supreme
They will
Court
have
full of
a
admiration for your
file
lordships,
earlier.
Lord. It's amazing.
Now what,
It's amazing.
last
One of
night
the
I was
selling
sitting
point
till
of the
late with
Chief
my
Justice
staff.
is
I said,
that
how do we
if you
find
use
this
a
solution?
digital device,
So now we are coming
you
out
will,
with a
as
solution
you
called
use more
versioning.
and more,
So the
you will
lawyer's
look
copy will
younger
have,
and
and our
younger.
copy will have the date, the time, and
Lord, it has taken
it's like
effect, Lord, evidently.
14 hours, 23 minutes,
But, my Lord, not only that, my
32
Lord.
seconds
Incentive, that's
on
the
such and such a
incentive.
date.
But not
So
only
we
that,
have
Lord,
to make
I
sure
as
that we are
a
on the
Lord
same
infrequent
version
version
as the
of the
bar.
Supreme Court, Lord, the transcription is
So
brilliant.
it has a solution.
Lord,
It
the
just
video
requires a little
conference
bit of
system
more
is
discipline on the
absolutely
part of
brilliant.
the
you
bar as
argued
well.
for such a long time
Lift the
post
latest
lunch.
Lord,
version.
it is
was
absolutely
absolutely
brilliant.
clear.
There was
Okay.
not even a moment where
I
we
dare say,
felt
my
we had
Lord,
lost the
I
did it in the
voice or,
hope that, this
that you're not
travels
able to
beyond
follow what you are
voices
saying.
in this
Lord,
court
it is
and people
absolutely
all
brilliant. And
realize
because
that
this
is
is a
being done now by
national
the
court
Supreme Court.
and people have difficulty traveling to the court, the cost expense mod, it is a wonderful
The latest
initiative. Lord,
version.
long may it continue. Lord, paragraph 8. Lord.
Get more and more
paragraph
lawyers from the
58
High Court will
deals
have
with the
access
question
to
of validity
digital courts.
of amended
So,
Article It should be so, my 31C. lord. And I'm sure your lordships are aware, my
In
lord, that
this
in
remote area is also
it is in this
people
light
coming
that the
from,
validity of amended
remote
Article
districts.
31.
Clarity.
Please, internet is available now
The
almost everywhere.
sentence
Not just,
starts,
the
paragraph
the
58, it is
significant
in this
constitutional
light.
cases, but
Yes, my lord.
simple cases
Can you read
involving
paragraph
citizens.
57
Of course, my lord.
in
My lord,
volume
it's a
5?
remarkable Yes, of course. movement forward.
In
Page
fact, what we have now done, I can share with you, I
2079.
mean,
Certainly, my
for
lord.
those who are
That may give
tech
us some
geeks,
Certainly.
more
that
clarity.
we are now
That's always a
migrating
peril of
all
this.
our
Contact
services
with,
into
it is in this light that the validity
what
of
is
the
called the
amended
Megaraj
Article
Cloud
31C
2.0,
has to be examined.
which is the cloud
Allow me
infrastructure
to read
created by the
57.
National
And I'm
Informatics
obliged to.
Center.
My lord.
So we've
Lord,
already
would your
migrated
lordship
most
mind
of
if
the
I read
applications to the
56
Supreme
only?
Court and of the
56
e-courts
only.
project also.
This, because it's
Almost
beautifully written
200
again. Lord.
VMs
The
have been,
significance of
have
the
been
perception
migrated.
that
So with
parts
the
3 and 4
cloud
together.
infrastructure now,
Yes, bro. That's at page
all courts can really go
2079.
online.
2079.
Earlier, we had some limitations because of the capacity, but which has, all of us have now moved into
I am
the
grateful to your lordship,
cloud
but I think it will be much
infrastructure.
better if I read both of
And
these.
these are
to you.
managed services. You don't have to maintain a building. You don't have to maintain, whole
Of course.
team of a cadre of technical personnel.
Of course, my lord.
It's all managed for you, and the data is all preserved on servers in India. So there's no problem of data going outside India or anything like that.
Lord, the significance of the
only
perception that
suggestion that I
parts
would make,
3
because
and
I know
4
your lordship
together
is at the
constitute
forefront
the
of this,
core
Lord,
of
is
commitment to
uniformity.
social
Your
revolution.
lordship system is
And they
so
keep
perfected.
together other
Lord, I wonder
conscience
why
of
other
the
courts don't adopt
Constitution
the
is to be
uniform
traced
system and the
to a deep
tribunals don't adopt
understanding
it
of the
also.
scheme of the Indian
In fact, I've got a
Constitution.
matter where
Granville
I've issued
Austin's
notice
observation
and
brings
appointed,
out the true
I think, 2
position
or 3
that
amicus.
parts 3 and 4
That should
are
come
like
up
two
probably once
wheels of
before
the
we close
chariot.
for the
What my
vacation,
lord,
just to monitor what
my
the
lord
High
the Chief
Courts will be
Justice spoke to
doing.
me the other day.
Some High Courts
One no less important than the other. You snap one and the other will lose efficacy. They are like a twin formula for achieving social revolution, which is the ideal which the visionary founders of the Constitution set before themselves. In other words, the Indian Constitution is founded on the bedrock of the balance between part Roman 3 and 4. To give absolute primacy to one over the other is to disturb the harmony of the Constitution. The harmony and balance between the fundamental rights and directive principles is an essential feature of the basic structure of the Constitution. Then 57. This is not mere semantics. The edifice of our Constitution is built upon the concepts crystallized in the preamble. We resolved to constitute ourselves into a socialist state which carried with it the obligation to secure to our people justice, social, economic, and political. We therefore put Roman Part 4 into our Constitution containing directive principles of state policy which specify the socialist goal to be achieved. We promised to our people a democratic polity which carries with it the obligation of securing to the people liberty of thought, expression, belief, faith, and worship, equality of status, and of opportunity and assurance that the dignity of the individual will at all costs be preserved. We therefore put part 3 in our Constitution, conferring those rights on the people. Those rights are not an end in themselves, but a means to an end. The end is specified in part 4. Therefore, the rights conferred by part 3 are subject to reasonable restrictions, and the Constitution provides that enforcement of some of them may in stated uncommon circumstances be suspended. But just as the rights conferred by Part 3 would be without a radar and a compass if they were not geared to an ideal, in the same manner, the attainment of the ideal set out in Part 4 would become a pretense for tyranny if the price to be paid for achieving the ideal is human freedoms. One of the faiths of our founding fathers was the purity of means. Indeed, under our laws, even a dacoit who has committed a murder cannot be put to death in the exercise of the right of self-defense after he has made good his escape. So great is the insistence of civilized laws civilized laws on the purity of means. The goals set out in Part 4 have therefore to be achieved without the abrogation of the means provided for in Part 3. It is in this sense that Part 3 and 4 together constitute the core of our Constitution and combine to form its conscience. Anything that destroys the balance between the two parts will ipso facto destroy an essential element of the basic structure of the Constitution. I'm deeply obliged to your Lordship. Now
It is in
58.
this light.
No, yeah, I'm deeply obliged to your Lordship. Now it's much better now, my Lord, to read 58. Because it is in this light that the validity of the amended Article 31C has to be examined. Article 13.2 says that the state shall not make any law which takes away or abridges the rights conferred by Part 3, and any law made in contravention of that clause shall to the extent of the contravention be void. Article 31C begins with a non-obstant clause by putting Article 13 out of harm's way. it provides for a certain consequence notwithstanding anything contained in Article 13. It then denudes Article 14 and 19 of their functional utility by providing that the rights conferred by these articles will be no barrier against passing laws for giving effect to the principles laid down in Part 4. On any reasonable interpretation, there can be no doubt that by the amendment introduced by Section 4 of the 42nd Amendment, Article 14 and 19 stand abrogated at least in regard to the category of laws described in Article 31C.
You will have to elaborate this.
I will. I'm obliged, Your Lordship. The startling consequence which the amendment has produced is that even if a law is in total defiance of the mandate of Article 13, read with Article 14 and 19, its validity will not be open to question so long as its object is to secure a directive principle of state policy. We are disposed to accept the submission of the learned Solicitor General, considering the two charts of the case submitted by him, that it is possible to conceive of laws which will not attract Article 31C, since they may not bear direct and reasonable nexus with the provisions of Part 4. But that, in our opinion, is beside the point. A large majority of laws, the bulk of them, can at any rate be easily justified as having been passed for the purpose of giving effect to the policy of the state towards securing some principle or the other laid down in Part 4. In respect of all such laws, which cover an extensive gamut of the relevant legislative activity, the protection of 14 and 19 will stand wholly withdrawn. It is then no answer to say, while determining whether the basic structure of the Constitution is altered, that at least some laws will fall outside the scope of Article 31.
Back to para 54 of Vaman Rao and try to reconcile.
Before you go to Vaman Rao,
Yes, Lord.
can I just highlight three things in this
Please,
particular para?
please.
Para 58, if you go to 2080,
Yes, Lord.
okay, at the
Yes.
last line on 2079,
Yes, Lord.
it then denudes Article 14 and 19 of their functional utility by providing that the rights conferred by these articles will be no barrier against passing laws for giving effect to the principles laid down in Part 4.
Madam.
So there are three observations in this para which are very crucial. So will be no barrier against passing laws for giving effect to the principles laid down in Part 4.
Yes, Lord.
So now they are saying that you are giving an immunity against a 14 and 19 challenge on the ground that the law is giving effect to any of the principles in Part 4. Second, now if you could just travel a little down, the startling consequence
Yes, Lord. I
which
have.
the amendment has produced is that even if a law is in total defiance of the mandate of 13, read with 14 and 19, now it follows. Its validity will not be open to question so long as its object is to secure a directive principle of state policy. That's the second.
My Lord.
They're looking at now the width of the amendment
Correct.
provision, that it gives effect to any of the directive principles. Third, a large majority of laws, the bulk of them can at any rate be easily justified as having been passed for the purpose of giving effect to the policy of the state towards securing some principle of the other laid down in Part 4. Three very critical observations in this paragraph. So what they find as objectionable is that there is a complete immunity to an Article 14 and 19 challenge if the law has been enacted in pursuit of any of the directive principles. Earlier, before the amendment, it was confined to specific directive principles 39B and C. Now they say what is objectionable is that canvas of immunity is extended so long as it is in furtherance of any of the directive principles. These three observations in para 58 are very crucial. Now, if you go down and travel to para 59 and then 60 for a moment.
Yes.
60 is very important.
May I read?
Very
Your Lord?
important because it deals with
60
Article 13.
because 60 dwells on what is referred to, in those three sentences.
Yes.
Any one directive some directive principle or the other. Now just see 60 for a moment.
May I read 60 for your Lord?
Yes.
Lord, and I return to your Lordship's point immediately after. Or it was repeatedly.
Para to 54 of Vamanra.
Actually, my lord, what your lordship has said, I believe, has in one sense answered my Lord Justice Pardiwala's point. I believe my Lord Justice Pardiwala's point was in 54, it was the specificity, the point which was made also by Justice Dhulia, of 39B and C, which allowed 31C to stand.
Right. So what Vaman Rao then says, we'll go to Vaman Rao in a moment, is that so long as that the ambit of Article 31C
Is narrow.
is narrow and tailored to Article 39B and C, it passes muster. Though Article 14 and 19 per se are part of the basic structure of the Constitution. Right?
Perfect.
What was objectionable in what was found to be objectionable in the 42nd Amendment in Minerva was that as opposed to a narrowly tailored immunity confined to laws in furtherance of 39B and C, you are expanding it to the entirety of the chapter on directive principles, namely part 4. Now see, para 60 will make that even clear. 60 makes it way. But that's why I highlighted those three.
I'm obliged, deeply obliged.
In para 58, where they refer to some article or the other, the entirety of part 4.
I'm deeply obliged.
Now just see para 60.
But can I say one more thing before I go to 60? Lordship permits me just a word. But all the cases, my lord, treat 31A, B, and C as one suite of provision.
Absolutely, one suite.
Or agrarian reform was the real driving purpose of 31A and B, and then came C. So it was always conceived as a very narrow balancing act that was done in favor of directive principles against fundamental rights. To your, my Lord Justice, to both points actually.
Lord, let's see para
Yes,
60.
now para 60. my lord. It was repeatedly impressed upon us, especially by the Attorney General, that Article 38 of the Constitution is the kingpin of directive principles, and no law passed in order to give effect to the principle contained therein can ever damage or destroy the basic structure of the Constitution, a point made by Justice Dhulia
Yes.
this morning. That article provides that the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may be a social order in which justice, social, economic, and political, shall inform all the institutions of national life. We are unable to agree that all the directive principles of state policy contained in Part 4 eventually verge upon Article 38. Article 38 undoubtedly contains a broad guideline, but the other directive principles are not mere illustrations of the principle contained in Article 38. Secondly, if it be true that no law passed for the purpose of giving effect to the directive principle contained in 38 can damage or destroy the basic structure of the Constitution, what was the necessity, and more so the justification, for providing by a constitutional amendment that no law which is passed for giving effect to the policy of the state towards securing any principle laid down? Yes, Lord. Perfect sense, Lord. Your Lordship is.
So really, Mr. Andarjuna, what the court is finding objectionable in Minerva is this expansion beyond 39B and C. So neither Minerva, and now we'll go to Vamanrao para 54 to deal with Brother Pardiwala's point. So what is objectionable even in Minerva? Minerva is not reconsidering, assuming Keshwanand was 5 judges and not 13. I'm just theoretically saying that. Then Minerva could have possibly reconsidered the validity of 31C all over again. They couldn't have done that in Minerva, but that apart, what Minerva is finding objectionable is not original Article 31C in its unamended form, but the amended provision which expands the canvas of 31C to cover all the directive principles of state policy.
But with respect, Your Lordship has perfectly articulated.
Now, if you come back to para 54 of Vaman Rao.
And not when we see that, Your Lordship will see that there's perfect symmetry
There is
between
symmetry between
Minerva and Vaman Rao. There is no asymmetry in the two at all.
Perfect symmetry between the two.
So, my Lord, if we go back, if Your Lordship
I'll
doesn't.
go back to 54.
My note.
Brother
My note. For my Lord Justice Padiwala's point.
That's all right.
But in fact, my Lord, that was the very point expressed from the Vaman Rao point of view by Justice
You
Padiwala.
have quoted 54, right?
I have. My Lord, it's at page 96. Roman 4.
Yeah, otherwise,
May I say something?
Please, my lord.
Because if you see the other directive principles, it speaks of village industries, cottage
Exactly.
industries, animal husbandry, living, what is that, wages,
Living wage.
protection of monuments, then protection of environment. All those laws will get immunity then.
But to my
That is why
lady,
it was struck down.
but to my lady's point, Lord, that is actually once again another aspect of this. The balance was lost. If you say that everything within Part 4 will take primacy, what about the earlier part which says that the constitutional tension is a part of the basics
The balance is preserved by 31C in its unamended form.
in an unamended form?
Now, once we accept that as the prevailing, the prevailing doctrine post Keshanand and even post Minerva and Vamanrao, we'll go to para 54 in a moment. Then the only point which we have to dwell on is what happens about that slightly problematic area. It's not a clear area of the entirety of Section 4 having been
That-
struck down.
but
That
this
is
only-
a problematic area, but then
This only clears the way for that argument.
do we then say that, look, it is a problematic area? Obviously, otherwise, we would not be laboring this point and, so many three referral orders. Then do we take a very strictly formalistic view of the law by saying that the moment Section 4 was struck down, the entirety of 31C is struck down? That would be a very formalistic reading of the Constitution. I mean, we are a constitutional court. I mean, we have to pay due deference to our peers and predecessors.
Understood.
Who came in and said, look, 31C in its unamended form is valid in accordance with the social ethos. Then we are only left with this point. What is the effect of a substituted provision having been...
Lord, your lordship is
down?
Perfectly correct. Lord, all of this
And
was
you
an
must also bear in mind, this is not really an absolute substitution. You were right when you said it can be by way of an addition, substitution, repeal. This was really a substitution coupled with an addition. But it was not a total substitution. They just changed those three words, Article 39 B and C, and said all or any
Or
principle.
any of the principles.
But I will try to deal with those issues also. And
Just read para 54 and then I think
we can go straight to that point.
you go to the last part, which
Yes.
is the heart of your submission.
Straight to that point.
And what is the effect of the declaration of Section 4 as unconstitutional? Does that revive Article 31C?
Yes, very well.
And perhaps the simple answer would be that, look, once 31C in its amended form is declared to be null and void,
Well,
subject to your caveat that it's not obliterated from the statute book, the Constitution, it's still retained, but it's always then italicized. It's in that sense from the date of its enactment, unless it is made prospective, from the date of its enactment or adoption, the amendment to 31C is rendered non-est. If it is rendered non-est from the date of its adoption in 1976, then the prevailing position which operated up to the date of the adoption of the Constitutional Amendment is not obliterated, unless there was intrinsic evidence that Parliament intended to obliterate by the constitutional amendment the earlier position. In some cases, for instance, there may be a clear intent of Parliament that, look, we want to obliterate a constitutional provision prior to the date and completely substitute a new provision. That is not the intent of Parliament. Parliament wanted to extend the scope of the immunity, actually.
but I will address your lordship on that as well. But I have some thinking on that, but I will address your lordship. But your
So
lordship,
just to show us para 54 and then you can go to that last part. now.
Perfect.
Then we'll call upon the other side.
yes. So, my lord, if your lordship will come straight away, my lord, to paragraph 54. But may I read it for you, lord?
Should we quickly, then
54?
54, I think you've read, Jamshi, you wanted to read? 54 we have read. Now go to the last
Straight-
point.
straight away.
That will take you just, the conceptualization.
Yes.
We want the conceptualization. Now
But
we've
may
seen the
I-
law, the judgments and everything.
Just say, but just to complete this, just two words, my lord. My lord, the succeeding judgments, Lord Bhimji Sen's judgment, Lord
Bhim Singh Ji is that.
Bhim Singh Ji's judgment, sorry.
By the way, Mr.
Sen-
Bhim Singh Ji used to come here. He was unfortunately passed away I think a couple of years ago in COVID or post-COVID. Used to
During
be up
COVID,
here.
I
Yeah.
think there was a reference made.
Singh Ji had filed a public interest litigation, which I allowed, where he said that the army porters who serve in the border areas, they have no security of tenure. They have nothing. If a porter falls, if any of you have gone to Ladakh and you see those porters just near the border areas, they are with their mules, and it's very treacherous. And he said, there's nothing. The man just falls, he's gone. There's nothing for his family. So we allowed his petition, asked the army to come out with a social welfare security net for, thanks to Mr. Bhim Singh. A very, puny sort of a person, used to come and make his point. But he headed the Panthers party.
Yes.
And the first judgment saying that compensation can be granted for a violation of fundamental rights is in Bhim Singh's. It was preceded by Rudul Saha was preceded by Bhim Singh Ji, where he was detained in Jammu and Kashmir in those days, and our court awarded some compensation, I think, to him. Then came Rudul Saha and D.K. Basu and everything. Yes,
My lord, just to complete that, my lord, the three judgments, my lord, Bhim Singh Ji, my lord Sanjeev Kok, and Basanti's case, my lord, they did not deal with a direct challenge to 31C. They all proceeded on the basis that it is valid today. And they were, my lord, in a challenge to the Urban Land Ceiling Act, a challenge to a part nationalization of Coal Mines Act, and a challenge to a different part of MADA as well. And my lord, of course, the Basanti judgment, my lord, was delivered by Justice Venkatramaya as he then was. But we don't have
Basanti
the
actually for a moment.
Mada, that is the 31.
MADA judgment.
Let's see Basanti because it deals with.
So, my lord, it is actually easily distinguishable, but we can see it, my lord.
Let's because I think Basanti, because otherwise they will cite it. We might as well look at it.
Yes,
They
ma'am,
can
please
just
do.
show us the relevant part they are relying on.
Please do. But I noticed that we don't have the historical problem that we have with Justice Chandrachud here with my lady, my lord.
Where are these judgments? Which volume?
Basanti Bai is in which volume?
My lord,
Just tell us. Actually,
Volume
this
5.
one, Julia said, just give us all the three because you
Yeah,
have given us
very
earlier.
good. Yes, I'll give your lordship all three. Not
Bhim
just-
Singh Ji is in which volume and which page? Volume 5?
It's all in volume 5. But give me just one moment, I'll tell your lordship what pages.
Any of the juniors on your side also have the pages readily? Can just tell us. Bhim Singh Ji is 2/4?
27. Basanti Bai, sorry.
Basanti Bai is at 2427.
Basanti is
2427. Lord,
192.
2294 is Sanjeev Kok. And 2192 is Bhim Singh Ji. Yes, my lord, 2427. But let me just show you. Just help me, where is it here? Or just give me a moment, please, Manoj, just a minute. The relevant parts. Lord. Yes.
Which is a relevant paragraph?
Yes. So would your lordship just like to see the challenge in Basanti Bai first?
Sure. That is
Why
at
it is
page
this-
2429.
2429, Lord. Lord, this appeal by special leave, Lord, it was against the acquisition of certain lands in Lonavla under different provisions of MADA. Lord, yes, chapter 5. This appeal by special leave is filed against the judgment dated 8 November 1983 in writ petition, by which the High Court declared subsection 3 and section 4 of section 44 of MADA to be void and gave certain ancillary directions. Lord, the facts are then stated, and then the question your lordship will find in paragraph 5. Lord, in paragraph 5 is at page 2432. May I? But in the course of this appeal, the parties have not questioned the correctness of the decision of the High Court as regards the facts which had been found against the respondent. The arguments were confined to the constitutional validity of subsection 3 and 4 of section 44 of the Act. Then, if your lordship would kindly go straight away to the discussion on 31C at page 2441, paragraph 13.
Para 13,244.
2441. But even granting for the purpose of the argument that subsections 3 and 4 of section 44 are violative of article 14 of the Constitution, we are of the view that the said provisions receive the protection of article 31C. We shall proceed to test the validity of the argument, keeping aside for the time being the observation in Sanjeev Co. Let us proceed on the basis of Kesavananda Bharati and Minerva Mills. Article 31C reads thus. Lord, clause B of article 39, which is relevant for our purpose. So, they proceed on the basis that it was very much alive and well, as your lordship says. States that the state shall in particular direct its policy towards securing that the ownership and control of material resources of the community are so distributed as best to subserve common good. The High Court rightly observed at the end of paragraph 14 of the judgment following Sanjeev Co. that the expression material resources of the community should not cover so and so. But, however, it erred thereafter in reaching the conclusion that Article 31C was not applicable to the case for the reason that the Act did not contain a declaration that it was enacted to give effect to Article 39B Roman 2 by undertaking development of commercial centers while providing housing accommodation. The authority was expected to make profits, and hence it followed that the power to acquire was not conferred with a view to achieving the directive principles of Article 39B. That was an important criteria in the decision-making of the High Court. And two, the object of enacting the legislation was obviously to provide wholesome civic life to the citizens and not distribution of material resources. We are of the view that each of these reasons is invalid and erroneous. First, Article 31C does not say that in an act there should be a declaration by the appropriate legislature to the effect that it is being enacted to achieve the object contained in Article 39B. In order to ascertain whether it is protected by Article 31C, the court has to satisfy itself about the character of the legislation by studying all parts of it. The question whether an act is in... Sorry. Yes, exactly. Exactly. That is the point which is made. It's an entirely different point from the point which presents itself before your lordships today. And it accepts axiomatically 31C to be
They
alive.
follow Sanjeev Kok and Ranganath Reddy. They
Perfectly.
follow Justice Krishnayer's dictum in Ranganath Reddy and say that it has now been adopted by a constitution bench in Sanjeev Kaur.
Perfectly put. Lord, that is the significance of this judgment. Lord, I have actually dealt with these three judgments.
Sent by Sanjeev. They cited the minority in Ranganath Reddy and say it was followed in Sanjeev Kok and therefore they are now.
Yes, but Sanjeev Kok itself is a remarkable judgment, Lord, where more or less the minority reasoning is preferred over the majority.
So now,
So, Lord, that's it.
the last part
Last
now
is all that is relevant. Lord, I only want to point out I've dealt with these follow-up judgments at page. Lord, the Lord, there's, if your lordships will permit me, one beautiful line in Sanjeev Kok, Lord, where Minerva Mills is described as a
rhetorical beauty is there.
rare beauty,
Rare beauty.
and persuasive rhetoric. Lord, I have dealt with these follow-up judgments in page 105 of my note. Just for your lordship's convenience, it's there. But can I take your lordship now, Lord, straight away? All this was to clear the path to say that I can argue this point. Lord, it is, this point remains. Now your lordship will assess the strength of this point, my lord. Lord, it is dealt with by my note which I had given to your lordship earlier. Lord,
105, right?
Note 3, yes.
Oh, note 3, not in this today's.
No, but it's in the earlier compilation notes. Lord. Yes, Lord, volume 1B, I'm told. Lord, whether Article 31C is a dead letter and whether unamended Article 31C should revive. Now, Lord, I'll just explain the note to your lordship in a second. There are two parts to the note. Lord, the first is what is the effect of the declaration of unconstitutionality upon the statute? Or that is the first part of the note. The second part of the note is dealing with this peculiar type of legislative activity, namely substitution and what it involves. So now these are two parts of the note. Yes. I'll just wait for all of your lordships to pick up that note. So,
Happy
is
of
that
that note?
page 38?
38.
But my learned friend, Mr. Devrajan, draws to my attention that I hope your lordships.
We don't
Cop-
have, I think, anything
Oh, I see.
beyond 37.
37, the note ends at, no, I have 38.
I'll see.
There is 38.
Well, just
It is there.
sorry.
Whether Article 31 sees a dead letter.
Yes, not whether it's a dead letter and whether unamended or stood revived. Now, Lord, if I take your lordships directly to paragraph 3, Lord, all of which is exactly what I've been arguing. Well, the judgment in Minerva Mills declared section 4 to be beyond the amending power of Parliament.
You are saying that once section 4 is declared unconstitutional, that can't be revived.
So, Lord, I'm saying two things. The effect of unconstitutionality by your lordships is not to excise it from the statute book. It still remains a part of the statute book. It requires legislative intervention to then actually delete it. And this is exactly what they tried to do in the 44th Amendment Act, if your lordships recall. Lord, the part which was struck down by Keshavananda Bharati, they actually moved to say delete it. But for whatever reason, that motion didn't pass the Rajya Sabha. So, my Lord, parliamentary practice.
45th.
45th, sorry, 45th. 45th Amendment Bill. Lord, it's a curious thing, but it's the 44th Amendment Act. So, Lord, it seems that there was one bill which didn't become an act. But I myself puzzled over that. 44th Amendment Bill was moved. That part which was allowed resulted in the 44th Amendment Act. So, my Lord, one bill around the way, my Lord, has got lost, missing, didn't pass.
That part
Yes.
not passed.
Yeah. No, my Lord, your lordship has observed that problem, my Lord. I myself noticed that. I tried to understand it. So, my Lord, this first part, my Lord, the argument is in two parts. My Lord, once Minerva declared section 4 to be unconstitutional, what was its effect on the statute book first? That's the first part of the argument. So, if my lady would kindly look at 3 onwards, or 4 onwards. It is submitted that the declaration by this honorable court did not and could not receive the unamended Article 31C. Sorry, could not revive, it should say. So, I'm so sorry, I misspoke. Could not revive the unamended Article 31C as stated and submitted below. Now, Lord, this is the reasoning about that declaration of unconstitutionality. When Section 4 of the Constitution was declared void, it cannot be said to mean that it was totally ineffectual and did not at all have the effect of amending Article 31C as contemplated in the 42nd Amendment. The substituted words continued to remain as a part of the Constitution, and here, my Lord, I have illustrated. But see Article 368, my Lord, I have quoted, thereupon the date of assent, the Constitution shall stand amended in accordance with the terms of the bill. So once the bill is passed, Lord, it effectively comes onto the statute book, and in the case of a substitution, in the place of the previous provision. There is a clear distinction on the effect of the statute when it is amended or repealed by a legislation and when it is struck down by a court for constitutional violation. So the two are different. Repeal is entirely different from striking down by a lordship's court. The effect of a legislation on the statute is a physical change. An express repeal, removing the statute out from the statute book. Parliament repeals, it's gone, it's deleted. An amendment makes physical changes in the statute, but a judicial decision does not make any physical changes in the statute. So I should say changes in the statute. It only places a particular meaning on it and leaves the statute on the statute book without any change. This difference is due to a clear separation of the functions between the legislature and the judiciary under our constitutional scheme. Note 7. No statute can go out of existence unless the legislature repeals it. The courts do not possess the power to make a statute or to repeal a statute. When a court declares a statute as unconstitutional, it is void. It is legally unenforceable, but factually, its existence cannot be wiped out by judicial declaration. In State of Bombay and F.N. Balsara, the Honorable Supreme Court had struck down Section 13 of the Bombay Prohibition Act 1949. This case dealt with a pre-constitution act. It was existing law on the date of the constitution. The question of the effect of its unconstitutionality, as so declared, came up first before a three-judge bench in Pesikaka's case, Behram Khurshid Pesikaka versus State of Bombay. Justice Bhagwati, N.H. Bhagwati, held that the effect of the declaration of unconstitutionality, there was a slightly different view here, was not to enact a statutory provision or to alter or amend Section 13B of the Act. So, my lord, one thing I hasten to act. Now, my lord, we are speaking about its effect on ordinary statutes. One of the problems that we have had here, my lord, there is very little material on this point. My lord, and that has been noticed also in the NGSC judgment, which, my lord, I will be making some submissions to your lordship on. With regard to its effect on the constitution, my lord, is very little tried and decided, as I will show your lordship. But there is one or two, my lord, in my respectful submissions, persuasive indications.
After the provision is struck down,
Yes, ma'am. Sorry, ma'am.
whether they are bound to carry out the amendment also, deletion, addition, whatever.
Well, your lordship has raised a very good point. My lord, they may allow it to linger on in the statute book, as has actually happened and commented on by Justice Chandrachud, my lord, as he then was. My lord, to say it lives an italicized existence. So, my lord, when your lordship finds in the statute books, my lord, many of the parts of the statute in italics, your lordship will find a footnote there to say that actually it was struck down by this. Parliament has not taken the necessary step for
Whether the
actually.
Parliament is bound to do it.
Parliament is not bound to do it. Parliament may do it, Parliament may not do it.
For a layman, it is very difficult to understand.
It
The
is.
kind of argument being raised here,
Yes, my lord.
that the earlier has revived.
My lord.
So nobody knows what was there, not there. So
Your
how
lordship-
layman will understand this thing?
No, your lordship is perfectly correct. My lord, I would submit to your lordship that for the orderly development of the law, Parliament must do one of two things. It must either remove it from the statute book, or it must remove the basis of its unconstitutionality and revalidate it by a parliamentary motion. That would be the correct parliamentary procedure, my lord. But I don't want to be misunderstood as raising a very technical point. But my lord, as I see it, this is an important point on the separation of powers between parliament and between
Statutes. And also provision struck down.
many statutes. And my lord, I would venture to suggest that in majority of them, parliament has not taken the necessary sweeping up action. Sometimes, my lord, in the ninth schedule, what was happening was that once it was struck down, it was immediately inserted into the ninth schedule to revalidate it.
Yes. But
So, but there also, Parliament is fully conscious of the fact that it requires parliamentary action for revalidation.
some is there, but
It is always done. Because striking it down leaves it hanging, but what do we do with it? But may I just return, my lord, to the note, my lord?
Because very rarely there would be a question that the striking down was bad in law at a future date.
Quite right. Quite right.
They don't do anything about it. They accept it unless they abrogate that judgment by removing the basis of the judgment,
My lady is perfectly correct.
validation or something.
Like, I'll give you another example.
My lord.
Although it's not a part of the constitution, but section 303 IPC
My lord.
has been declared as unconstitutional by the Supreme Court.
My lord.
It still exists in the statute books.
Your lordship is
Ineffective.
yes, ineffective, void actually, void.
Similarly, is this post Minerva, the status of the 31C.
Yes, your lordship is right. It's still there.
You can put it in an article somewhere. Effectively, it's nothing.
So, my lord, this requires a little, because the courts and parliament always work in tandem. At least the Supreme Court and parliament is to work in tandem. What the Supreme Court does, well, it may be accepted by parliament. Then you do away with it. You may not accept it, change the basis of it and revalidate it. But, my lord, parliamentary inactivity, in my respectful submission, results in the situation that we are in today. And it is difficult to see who can do it but parliament. So, my Lord Justice, Chief Justice put it to me, is this a technical point? Parliament can easily revalidate it. Of course it may. But, my Lord, Parliament in 2024 may take an entirely different view with regard to the insertion of an article which was done in 1972. It may delete it. It may revalidate it. It may bring it back in some other form. But these are all matters for Parliament to now decide. The baton, as it were, is handed over to Parliament to do what it will. And the unsatisfactory consequence of this, that yes, we are left without the article Lord, is a logical sequitur if we accept the fact that this is something which is left for Parliament to do. My Lord, I absolutely see the fact.
What is the logical sequitur of what you're arguing if the declaration of unconstitutionality does not efface the provision from the Constitution? It remains a part of the Constitution, but it becomes unenforceable. It
Yes.
becomes void and unenforceable.
Unenforceable.
Now,
That takes me to step 2.
what is the step 2 then?
So step 2 is that in the case of a substituted provision,
Yes.
what is remaining on the statute book is the unenforceable provision. That is actually, I'm glad your lordship asked,
In
that
the
is
case
surely
of-
the logical
Can you just
consequence of
say
this.
that again? In the case?
But in the case of a substituted provision which is declared unconstitutional, the same remains on the statute book, but is ineffective and is in fact void. And my lord, if your lordship were to push me a little further, my lord, I would have to say that there is no room for two provisions, one of which has replaced the other.
What they are arguing is the effect is that.
Is that exactly? Or what my learned friend.
So really speaking, what you're saying is this, that when Parliament substitutes in its constituent power a constitutional provision, then the effect of that is that the original provision
Extinguished.
is completely extinguished.
Extinguished.
That does not remain on the statute book because it's Parliament's power.
My lord.
But when the substituted provision is declared to be unconstitutional by a court,
My lord.
that substituted provision still remains on the statute.
Very
book,
much so.
albeit it is unenforceable. So the declaration of the substituted provision as unconstitutional by the court will not revive the earlier provision because the court does not enact a law.
Lordship has put it perfectly, but if I were to slow your lordship's
We'll
process,
hear the other side on this.
but if I were to slow your lordship's process down by just one step, Lord, I would say that the declaration of unconstitutionality, Lord, brings to an end your lordship's examination of that constitutional provision. Your lordships cannot even say it stands removed from the statute book. It is now handed over to Parliament, who must take the necessary action on it.
And if it doesn't?
But we have the situation which we have today.
No,
It's a dead
but
letter.
will there not be something like an implied revival, something like that?
No, but
But see, your argument is actually very attractive.
my lord,
Philosophically, theoretically, it's very attractive.
my lord. No, my lord, I understand the pragmatic problem. But I understand the pragmatic problem that I'm faced with, and I understand the fact that it's viewed as a technical argument.
Access between there you have.
That point remains. But whatever else is there, that point remains. But let me try during the course of the argument to address that point once again. I have a separate section, but where I'm going to try to address that point once again as well. Yes. Please.
Propose what fell from my lordships, my lords. Today, by a process of interpretation, they want your lordships to do something which Parliament said it won't do. That may kindly be considered, my lords. Parliament said it does not want 39B and C in its old form. That's why the 44th Amendment Act did not bring it in. Though the bill contained it, the act did not come. So today, by process of interpretation, they want your lordships to bring in something which Parliament said it won't do, my lord. My lords may kindly consider this subject.
I am very obliged to my learned friend, actually. My learned friend.
Not an NJC case for that.
We are going to the NGSC case.
You are relying on that.
Yes, but I'm going to show your lordship the NGSC case.
Just read the Article 31C now, what sense it makes.
It makes no sense. Your lordship is perfectly correct, if I may say so.
If the deletion is deleted, whatever is struck down is ignored.
It is
there
actually completely emasculated.
no sense.
The only way it can make sense is if the old revives.
Yeah.
That is the only way it can make sense.
If you pick up the book,
Yes.
then there is only part 4.
There's only part.
39 BC, as it was earlier.
Your lordship is right.
But then we'll have to read it.
But and your argument has a fiction implicit in it.
Well,
That You see, normally when Parliament say substitutes an original provision,
My lord.
that substituted provision ceases to be on the statute. Right? Forget this particular case. When Parliament substitutes a provision in its constituent power,
Yes.
the original provision ceases to exist. It ceases to be on the statute book. When the court declares or strikes down the substituted provision, it continues to remain on the statute book, albeit it
In
is
effect.
rendered unenforceable, null and void.
My lord.
So therefore, according to you, and that is following the doctrine of separation of powers, that it is only Parliament which can efface a provision from the statute book. The court can only strike it down as unconstitutional. So when the court strikes down a provision as unconstitutional, that does not lead to the revival of a substituted provision which is exclusively within the domain of Parliament.
And there, my lord, your lordship once again has put it perfectly. But I would just add one or two perhaps logical extensions to that.
That's your argument, really.
That is my argument. But my learned friend, Mr. Devrajan, raised an excellent point, my lord. Parliament may express its parliamentary intent at that stage. It may say that I accept the advice given by the courts. I accept the fact that in fact it should go and it is unconstitutional.
For the court to revive a provision, according to you, is for the court to exercise a constituent power.
My lord. My lord. This, in a nutshell, is exactly what I've been saying.
You were not here yesterday, Mr. Devedi was making this point,
I heard it.
that it's just one exercise. It's not that if the 39th BC will not come, because it becomes void ab initio.
Yes.
And if it is void ab initio, the 39 BC will automatically come, as if it was there in the statute book.
Yes, my lord. I heard my learned friend, my lord, and my lord,
Just because.
I have got some way of dealing with that, my lord. If your lordships permit, I'll just come to that at the conclusion of this. My lord, I want to deal with that in a separate way, my lord. About the effect of that unconstitutionality and the fact that it relates back to the date of origin of that particular constitutional provision. But I have some thinking on that also, because I heard, my lord,
It goes back to the original.
it is well settled that when your lordships declares it's void, it relates back.
Unconstitutionality relates back
Relates
to
back.
The date of the 42nd Amendment.
So yes, my lord, I accept that, but there are just two academic possibilities. My lord, one is that it relates back to 1972. That's a possibility. Well, that's all I'm saying, because what has happened is that it's a 72 provision amended from time to time, because another problem is, take the 44th Amendment Act. 44th, why should it not relate back to the 44th Amendment Act then? Why only the 42nd Amendment Act?
Well, now the amendment of the 42nd Amendment, was it retrospective or it was prospective?
Prospective. I think it has always been understood thus. But that's Vaman Rao. That's exactly what Vaman Rao says.
Probably this void has been noticed by a foresight in Vaman Rao, and they fall back on Keshwananda Bharati
To say it
say
exactly.
that the unamended provision was upheld in Keshwananda Bharati, and therefore they say that it is still alive and kicking.
Well, Lord, I have had a similar thought about Vaman Rao, because Lord, I wonder sometimes what was the contribution of Koilo, because Vaman Rao came so close to saying that 14 and 19 is basic structure. It just didn't say it in a sentence. And that was in 1980. So, Lord, the contribution of Koilo of 9 judges in 2017, seven, what was adding just that one few more words to nail it to the mast.
Even if 14 and 19 are part of the basic structure, as we will have to now proceed on the basis of their being a part of the basic structure, that does not still dilute the rationale of Keshwan Bharati, which is that it's not really a widespread or total, destruction of the basic structure.
It's a balance.
It's a balance, and therefore it is valid.
It's a balance. And Koilo is still relevant. What I had mentioned to your lordship on that what Koilo should not be read as an absolute proposition to say that the minute you come against 14, it is something which will be struck down. What 14 is a nuance. At 14, 21 are nuance. But we must apply the essence of that to the question. So it's just an oblique infraction. But may or may not result in the statute being struck down. But to the pith and the substance of 14, Lord.
So really, your argument really, which they will have to meet us in two steps. First, that when Parliament adopted the 42nd constitutional amendment, the effect of the 42nd constitutional amendment was that original Article 31C
My lord,
ceased to be on the statute book.
my lord.
Two, when the amended provisions of Article 31C were struck down by the court in Minerva Mills,
My lord.
the provision does not get effaced from the statute book. It remains on the statute book, but it is unenforceable.
It has lingered on as a dead letter.
Third, the declaration of unconstitutionality by the court will not lead to a revival of original Article 31C for two reasons. Bracket 1, the court, by the declaration of the substitution of the provision by Parliament in the 42nd Amendment, had effaced the provision from the statute book. And two, the court, being treated to have revived the original provision, will be again an act of a constituent power, which is not open to the court. I think that really is the
Your lordship has
logical,
perfectly encapsulated lordships to consider. Lord, I'm a little adrift here because, my lord, I find no basis for one or the other. But, my lord, when the court declares the provision unconstitutional, it does so taking the provision as a whole, because that's the only provision available to it. And therefore, my lord, to what point does the unconstitutionality relate back? Well, that is how I was attempting to do with my learned friend, Mr. Divedi's argument. It is not clear to me that it should go back only to the point at which the amendment made, because that point is no longer a point of significance, because it has now become entirely a new provision as of the date on which it was incorporated. There is only one provision. So what is not
There is
clear.
only one provision which is left, that 31C post the 42nd,
Exactly.
according to you.
But it is not like
The
a
original provision was completely wiped out when it
Wiped
was
out.
substituted. And according to you, the declaration of unconstitutionality will not amount to a revival of the original provision, for the reason that has to be in the exercise of the constituent power, which the court does not wield.
The constituent power is the main point,
You made
actually.
the point. Should we call upon the other side now?
But shall I show your lordship the authority on the topic before lunch?
Just quickly, you can
Quickly.
show us in 5 minutes. the
Quickly,
authority,
quickly.
so that then we'll have to get the other side. We have to wrap up today.
Yes, I fully understand. But very quickly. But my learned friends also want to say something.
Now we have to go to the other side.
There's one addition, there's one additional
Let
issue I can
him
take
argue. Let him-
as little
The
time.
link is also broken. Yes.
Lord, I'll run through my note. Summarize that. I'll summarize that. If I don't.
Yeah, the authorities, and then you can briefly
I've-
dwell on Coelho also.
I've actually-
Briefly, you can tell us so that they have a full, otherwise, again, we'll be calling upon
Very
them.
well. But if your lordship just sees my note, I've extracted it once again.
Yes.
What page 40?
Page?
40, 40. Lord PDF 40. Just one authority which was very good, which is not there. I'll just show your lordship from the compilation. But first on the effect of the declaration of unconstitutionality. But please see from paragraph 9 onwards. I'll finish this in 2 or 3 minutes. Paragraph 9, page 40. But, in the Constitution Bench decision of B.K. Pesikaka, Justice Mahajan for himself and Justices Mukherjee, Masan, Hassan, and Bose held as follows. The result, therefore, of this pronouncement is that the part of the section of an existing law which is unconstitutional is not law and is null and void. For determining the rights and obligations of citizens, the part declared void should be notionally taken to be obliterated from the section for all interests and purpose, though it may remain written on the statute book and would be a good law when a question arises for the determination of the rights and obligations incurred prior to 26 January 50. Justice Das in the minority said this. No part of the section is obliterated or scratched out from the statute book or in any way altered or amended, for that is not the function of the court. The judicial declaration that a part of the section is unconstitutional and void only nullifies that offending part in the sense that it renders that part ineffective against the inapplicable to a citizen who consumes or uses, or in that case, liquid medicinal preparations, so on and so forth. Or in another judgment, my lord, which puts it very well, my lord, which is the Sundaramaiah judgment, my lord, dealing with the Post-Constitution Act, and after considering the judgment in Pesikaka, my lord, it was held this. Thus, a legislation on a topic not within the competence of legislature, and a legislature within its competence but violative of constitutional limitations, have both the same reckoning in a court of law. They are, both of them, unenforceable. But does it follow from this that both laws are of the same quality and character and stand on a different footing for all purposes? This question has been the subject of consideration in numerous decisions in American courts. Oh, I'm sorry.
And the preponderance of authority in favor of the...
And the preponderance of authority is in favor of the view that while a law on a matter not within the competence of legislature is a nullity, a law on a topic within its competence but repugnant to the constitutional prohibitions is only unenforceable. So you may have two views about what is their effect depending on what was the type of challenge. Now, my lord, or some high scholarly authority, my lord, what Mr. Sirvai, my lord has summarized the law on this point as follows. My lord, the practice, I believe, is that never to cite living authors in this court. Lord, when a court declares a law to be unconstitutional, that declaration does not repeal or amend the law. For to repeal or amend a law is a legislative and not a judicial function. And my lord, then the next, my lord, authority, my lord, Khairiti Lal's case, my lord, Justices Fazal Ali Jaswant Singh, my lord, and approved by Justice Deshpande, is in the dissenting judgment of, approved the dissenting judgment of V.S. Deshpande and followed the same line of reasoning on the following lines. On a consideration of the circumstances, facts, and authorities discussed above, in our opinion, the following legal propositions emerge. When a statute, either as a whole or a part, is declared void, it means that the portion which is declared void is ineffectual, destitute of any legal effect, and not binding on the parties. Nevertheless, the Act remains on the statute book for the consideration of legislature in order to repeal or amend the same and for using it for some other collateral purpose. Number, that's the first part of it. Now the second part. So not the substitution part. Actually, what happens when you make the substituted law?
Now, what had Section 4 done? What was declared unconstitutional was Section 4.
My lord.
What had Section 4 done?
It had widened the...
Had it substituted and widened, or did it only...
But it had substituted in my respect. So, substituted and widened is not wrong. But widened by substitution is what I would say. But I think it is very difficult to see
So the substitution was not, could not have been divorced from the widening, right?
But
4 did
I
two
would say
things.
that.
Section 4 did two things. It substituted the earlier provision and it widened the earlier provision.
The whole point of the substitution was the widening, but it did so by the
Was
act
to,
of
was to
substitution.
widen it.
Yes.
Now, if that has been declared unconstitutional, Section 4 is declared unconstitutional by that operative part in Minerva,
Yes.
right? What is the consequence then?
But the consequence is that actually Article 31C altogether is unconstitutional and remains a dead letter till such time as Parliament steps in and takes the necessary legislative activity. Or that is the, and but I hasten to
But
add,
the substitution was for the purpose of widening.
but my lord, because of the fact that in widening you've obliterated the old section, but that is the part of my note that I just come to now. That is the legislative
Also
process.
look at it in a slightly different perspective, that the substitution was not for the purpose of obliterating, but the substitution was for the purpose of widening,
I follow you, Lord.
right? That Parliament never intended to dilute the protection under 39B and C. They wanted to really make that protection on 39B and C plus the other provisions of the directive principles, right? So the purpose, in a given case, Parliament may want to obliterate the provision completely and then substitute, okay, which was actually the NJSC case. But here, this was not a case of obliteration. What Parliament intended to do was to expand the ambit of the protection. Now, therefore, it was not a substitution and obliteration per se, but a substitution and expansion. Now, if Section 4 is declared to be invalid on the ground, primarily or exclusively, that the expansion was invalid, and conscious of the fact that the original provision had been already declared to be valid, then will this doctrine apply in a situation like this?
But let me try to answer that, my lord. Because your lordship has, my lord, once again, my lord, raised a point, my lord, that must be considered. My lord, when the scope of the article stood expanded, I asked myself one question. Could it be simultaneously also considered to be narrowly in the form of its original form? The answer must, that's the first step of my reasoning. The answer must surely be no. The article now stands in expanded form. But I want to also take the converse, my lord. Let me assume that the article was originally in expansive form, and by the amendment it was narrowed down. But in my respectful submission, the same would follow, that it is now only the narrower interpretation that has any force. But it is very difficult to view substitution as a single stage process. And that is the point. I'm glad your lordship asked me this question. It is always a two-stage process, which is exactly what the authorities say which come. The first is deletion of the original provision, and the second is to insert the new language. Now, my lord, there is some inexorable sort of consequence of that. That is the argument on the other side. I will deal with
That
that.
cannot strictly apply, Mr. Andarjana, to a situation like this, where the deletion of the original language is not the purpose of the substitution, because the original language gets incorporated in the new provision.
I understand. Your lordship has raised a very good, my lord, conceptual problem, conundrum.
So, you know, there may be a...
So, my lord,
Using spaces with the same ink.
what's it? So, my lord, to your lordship's point, my lord, 39 BNC remain within the expanded conception of
So we got your point.
Yes.
The moment that Parliament, in its constituent power, substituted and expanded the words, expanded the protection of 31C, the original provision was completely knocked off the Constitution.
Deleted.
Thereafter, when Section 4, which substituted and incorporated the new provision, is declared as unconstitutional, then according to you,
There is nothing to go back to.
the substituted provision doesn't get revived, because that substitution has been attained finality, though it happens by the same act of the legislature in its constituent capacity. According to you, the first part attains finality. The declaration of unconstitutionality attaches to the latter expansion. That will not result in revival, because revival is the constituent power. I think we'll now close it at that and call upon the other side.
Very well. But may I just indicate 2 minutes to your lordship?
And also see, I think Zile Singh's case, that it is written with the same ink on the.
I wanted to show your lordship just that.
When the substitution takes place, the original is effaced.
But please look exactly at that.
Case.
Lord, it is, I put it through another case, but the pen and ink theory,
Where is
exactly
that?
the point.
Pen and where is that?
Paragraph 19 and 20.
At page?
Page 43 and page 43. But the act, just allow me to read this more before we close. The act of substitution in effect consists of two steps. First, the old provision is made to cease to exist. Next, the new provision is brought into existence in its place. Even if the new provision be invalid, the first step, that is the old provision ceasing to exist, is not undone. It remains in effect, and it is for this reason that the old provision cannot revive. This is now firmly established by the following decisions, not all settled authority on the topic. Now, to the pen and ink theory. But paragraph 20. The pen and ink theory first set out in the judgment of Justice Bose in Shamrao Parulekar, where it held that. But the rule is that when a subsequent act amends an earlier one in such a way as to incorporate itself or a part of itself into the earlier, then the earlier act must therefore be read and construed, except where that it would lead to a repugnancy, inconsistency, or absurdity, as if the altered word had been written into the earlier act with pen and ink, and the old words were scored out so that there is no need to refer to the amending act at all. This is the rule in England, see Craze on statute law. It is the rule in America, see Crawford on statutory construction, and it is a law which the Privy Council applied in Keshoram Podar and Nandulal Malik. Bearing this in mind, it will be seen that the Act of 1950 remains the Act of 1950 all the way through, even with its subsequent amendments. Therefore, the moment the Act of 52 was passed and Section 2 came into operation, the Act of 50 meant the Act of 50 as amended by Section 2. That is to say, the Act of 50 now due to expire on 1st October 52. The aforesaid judgment has been followed. Lord, in this, Lord, and I might have missed my lady's judgment, but I'll check that and update it as well.
Singh versus State of Kashmir.
I'm obliged.
Jammu
But I
and
will
Kashmir
do that
versus-
also. But just one last word I want to have before Your Lordship goes. Lord, I know that one way of viewing my argument is to say that you have raised a point of high technicality, but I'm conscious of that. But, my Lord, in my respectful submission, the correct way to view the argument is that it has raised an important point with regard to the effect of unconstitutionality and to the separation of powers. But it raises 3 points really. But the effect of unconstitutionality on the judgment, Lord, the parliamentary procedure involved in substitution, and thirdly, Lord, what is the constituent power and whether this type of action, the revival, is something which resides, Lord, with Parliament and not with the courts. Lord, the consequence of me being right, Lord, is hardly going to result in some sort of constitutional chaos, Lord, as was the case in the NGAC judgment. Lord, for 22 years, Article 31C was not even on the statute book. Lord, Chief Justice Chandrachud's observations in Minerva Mills, namely that you don't need 31C if the law is correctly made towards the purpose of 39B and C, because a challenge under 14 and 19 could then never survive. So, Lord, in my respectful submission, Lord, it would be appropriate that Parliament expresses its will by appropriate legislative action with regard to 31C. Well, I'm deeply obliged to Your Lordships. My learned friend Mr. Parekh wants to say a few words, Lord, and will not keep Your Lordships from lunch, I'm promised.
There was one third issue, Lordship. I'll finish by 1 o'clock. My Lord, there was one third issue which has been.
30 seconds now. You heard.
No, my Lord, I just want to point out one issue. There is a third issue which is specifically that we'd argued, 5 judges referred it to 7, which is on Sanjeev Kok. Sanjeev Kok does 2 things. It does not only confer or follow the dissent in Ranganath Reddy, it also follows the dissent in Minerva Mills. So Sanjeev Kok does 3 things, and we specifically raised it in para 17 has been doubted. I just want to indicate, and on first principle I'm saying, what Sanjeev Kok does is 3 things. First, it doubts Minerva Mills specifically, but says that because the review petition is pending, we are not saying anything further. But it follows Minerva Mill dissent, saying that once 39B is in, Article 14 is out. And that is an issue that we specifically took up in Coelho to argue that even if it is protected in that case under the Schedule 9 of under Article 31B, 14 is not fully out. It may be a higher threshold, basic structure issue may be involved, but Article 14 is not out, and that's para 17 is what we challenged of Sanjeev Kaur to say that the intent of 39B is not to make arbitrary law or make it in a manner that is discriminatory. And therefore, Coelho specifically said that 1419-21 is imbibed in the whole constitution. And therefore, even if you're seeking to go ahead with the purposes of 39B, the constitution can never be said to intend that you do it in an arbitrary manner. And therefore, it may be a higher threshold, which may be a combination 14, 19, 21, or that 14 which affects the basic structure. 14 is still available. And therefore, we challenged specifically 17 of Sanjeev Cook, and I wanted to point that out and make 2 or 3 submissions because today we are on first principle. My lords, if it was a smaller bench holding that what is the effect of Minerva Mills, my lords may proceed in a different manner. But today, as 9 judges, my lords can certainly say, and even today find that Minerva Mills was right, or what is the impact of Minerva Mills, and you hold the whole thing. And that again, Mr. Andhyarujina pointed out, the series of judgment, now 2 judgments of 9 judges, both in Puttaswamy and Coelho have said that Constitution is a living document. From time to time, you may interpret it differently. And therefore, we want to raise this specific point, one on first principle, since it's open to my lords to confirm Minerva Mills or vary it or whichever you like. My lords can today hold, and we don't have to strictly go by the interpretation, what did Minerva say, what is the effect. Today, my lords are in a position where my lords can today say that we find that the amendment is bad and therefore it must go. Because if Article 14 is the essence of the Constitution, then even if you want to achieve the purposes of 39 B and C, you cannot do it in an arbitrary manner. You want to take away my property, you cannot do it in a discriminatory manner. You must follow some process. Even if you want to take over coal mines, etc., you cannot say, I do not like Mr. X or Y or Z, and therefore I only acquire your property and next door I do not. And that's the consequence if my lords holds 31C. And much water has flown down the Methi River, if I may say so. Article 31A is there. The A, B, C, none of them were there in the Constitution. A protects all agrarian reforms. B protects anything put in the 9th schedule. 31C today is irrelevant completely because if anything the parliament wants to protect as a matter of 31A, it can protect it. If anything has to be put in the 9th schedule by a constitutional amendment, they can put it in the 9th schedule. And Coelho now protects me that maybe a higher standard, but 14 is still available to me, even if you put it in the 9th schedule. So therefore, 31C today has no substance, and my lord sitting in a combination of 9 judges can certainly decide that. And therefore, our submission is that para 17, and if my lords permits, that's really all I want to say, but I wanted to show a few paragraphs of Sanjeev Cook because it says these 3 things as I pointed out, and para 17 is what we had challenged. If I may, if my lord permits, page 2294 of volume 5 is where Sanjeev Cook starts. My lords, if my lords come straight to page 2308, volume 5.
What para is it?
It's para number 13. It starts at 2307. Three paras, my lords, I'm seeking permission to read, and then I'll close. Paragraph 13 starts at 2307. My lords have. The Keshwananda Bharti case, the court expressly ruled that Article 31C as it stood at the time was constitutionally valid. No doubt the protection of 31C was at that time confined to law giving effect to the policy under B and C of Article 39. The Constitution 42nd Amendment Act, the protection was extended to all laws giving the effect to all or any of the principles laid down in Part 4. The dialectics, the logic and rationale involved in upholding
2307.
2307, it starts at the bottom, last paragraph.
Para 13. Yes, you can
Lordship.
start.
First, it cites Keshwananda Bharti upheld the unamended 31C. Then, my lords, is 2308.
Yes.
My lord. By the Constitution 42nd Amendment Act, the protection was extended to all laws giving effect to all or any of the principles laid down in Part 4. The dialectics, the logic, the rationale involved in upholding the validity of 31C when it confined its protection to laws enacted further to 39B and C should uncompromisingly lead to the same resolute conclusion that Article 31C with its extended protection is also constitutionally valid. No one suggests that the nature of the directive principles enunciated in other articles of Part 4 of the Constitution is so drastic or different from these directive principles B and C of 39 that the extension of constitutional immunity to laws made to further those principles would offend the basic structure of the Constitution. In fact, no such argument appears to have been advanced in Minerva Mills case, and we find no discussion and no reference whatsoever separate to any of the distinct principles enunciated in the individual articles of Part 4 of the Constitution of Minerva Mills. The arguments advanced and the conclusions arrived at both appear to be general, applicable to every clause of Article 39 and every article of Part 4, no less clause B and C than the other clauses. We wish to say no more about the Minerva Mills case, as we are told that the pending review petition is
They
pending.
doubted Minerva. They had to refer it to a larger bench. They couldn't have said this in the face of Minerva.
I'm grateful, my lord, and that's what we pointed out, that this is most improper, because sitting there, in fact, they are, and I did not read all those paragraphs because of paucity of time. In fact, they quote the entire dissenting judgment, in this case, from Minerva Mills, and therefore, also I'm urging that this honorable court in this combination may confirm Minerva Mills, because it's too late in the day to now say Minerva Mills was wrong. And in fact, Sanjeev Cook doubts that. Then, my lords, para 15 onwards, and again, paucity of time, I'm not reading 15, 16. If I can come straight to 17, 17 is what we are. Because no, not confirm in the sense that only Sanjeev Cook doubted the correctness of Minerva Mills, saying that issue doesn't arise. They say that it is obiter. There are findings.
In fact, in para 16, they say we broadly agree with much what has been said by Bhagwati Jay in the extracts.
Lordships, I'm deeply obliged, which is why, in fact, this judgment seems to suggest that the dissent is correct. And there are findings which say that Minerva Mills findings are obiter because they didn't arise. And therefore, it would be appropriate today, in 2024, my lord, at the stage of constitutional history we are at, to confirm that Minerva was absolutely right, that both 3 and 4 are part of the same chariot, as my lords have called it, and both must work together. The aim in Part 4 must be achieved through constitutional means of Part 3. You can't say I jettison Part 3 because I have some great objective to achieve. Therefore, you can't say I like industrialist XYZ, and therefore I'll acquire their property because it's still 39B, but I don't like A by ABC, therefore I will not. Article 14 is that. There's nothing more to Article 14. It must be non-discriminatory. You can't pick it at your whims and fancies. And therefore there are multiple observations here which say Minerva Mills is only obiter. There is no finding there. And that, my lord, may clarify. That's all I was saying. But after that, my lords may see 14, 15 onwards is the second question, which is finally decided in paragraph 17. And this is what we were challenging, and that is what 5 judges, when they referred, are also referring to. And that's why they were waiting for Coelho. And this is, if I can point out, para 17, page 2312. Just this last para, 17. We are firmly of the opinion that where Article 31C comes in, Article 14 goes out. We are challenging this, my lords. There is no scope of bringing in Article 14 by a side wind, as it were, that is by equating the rule of equality before the law of Article 14 with the broad egalitarianism of Article 39B, or treating the principles of 14 as included in principles of 39B. To insist on nexus between the law for which protection is claimed and the principles of 39B is not to insist on fulfillment of the requirement of Article 14. Now, much water has flown down the river since then, my lords. I would submit that today, my lords may hold that certain principles of 14, certainly, which will in fact impact the basic structure, can be a ground to challenge. Even if my lords holds that 31C is there, 39B is there, even then certain principles, and that is an issue that we specifically raised and was referred, and 5 judges and 7 judges therefore referred to these issues. Sanjeev Coke, I.R. Coelho, that's why they said wait for Coelho. And that's the logic in which this. So therefore, my lords, today I would submit that my lords may hold and my lords can hold that Article 14.
Article 14 goes, you have read that particular paragraph.
Gotcha.
Article 14 goes, Article 19 goes, if a reasonable nexus is established
Gotcha.
between the statute and 39
Gotcha.
BC.
Gotcha.
In that context, it is saying that Article 14 goes.
Gotcha. Therefore,
There is no
it's not a
nexus.
sweeping remark. Like
no
that.
difficulty, Justice Dhulia is absolutely. But no, that's not. That's why after Coelho, that is not the law to this extent, and that's a submission that 1419 at a basic level may go, but if it amounts to affecting the basic structure of the Constitution, 1419 will still remain for a challenge, despite a protection from Article 31C. And I hope I've made that point clear. It may be a higher standard. It may not be the normal standard of 1419. But if an act protected by 31C with a nexus to 39B and C still violates the basic features of the Constitution or basic structure of the Constitution, it will still be open to this court to say under Article 14 we hold the law to be bad. And that's the context, and that's the constitutional development my lords have, in fact, over the years. 1419 has been raised much higher than it was at this stage of the constitutional history. And if I submit, my lords today can declare that 31C is no longer there. I don't only rely on revival or all those doctrines. Today, I submit this court can decide that 31C is bad. 31A and B are already there. The two article part 3 and 4 should be read together, and therefore, in fact, and 1419 to some extent is available. That's all our submission.
We'll
Gotcha.
commence after lunch. No, we'll call upon everybody. We can't have this, people repeatedly coming back and arguing. Now we'll call upon the other side.
Releasing judgment is 2004-8.
Yes. Ask him to take it.
Seek your lordship's indulgence to begin my story with Article 39 and not with 31C.
With Article?
With Article 39.
Yes.
As far as 31C is concerned, while a lot of things have been stated, both ideas, facts, concepts, which need a little more discovery, exploration, and response, if you may state like that. I thought better to engage the court first on 39 and then come to 31C later. There's a good deal of literature available. You'll have to permit me to make some broad preliminary statements, which are like a commentary on our constitutional history. A good deal of literary statements on the first 2 decades of our constitution, when the state was grappling with the issue of harmonizing fundamental rights and its obligation to direct from state policy. Professor Tripaঠি's book on fundamental rights was a textbook it used to be in the early part of our curriculum. When all those eras were about understanding the dynamics of Part 4 of the Constitution, and when they get interlocked with citizens' claim on fundamental rights. You go back in point of time to how certain provisions of the Constitution came to be enacted and became part of the Constitution, particularly Part 4. We have so many explanations, theories, and so on and so forth. Particularly in the context of Article 39 and few other provisions of Part 4. And those who want to draw one particular picture will say, well, this is a Marxist idea or a socialist idea, Irish constitution or a Japanese constitution, so on and so forth. But what is most important for us, I thought, is when constitutions are enacted, there are certain constitutional ideas which part of what called the understanding of the times. So there's a nice German word for it. Suppose what called the Weltanschauung, or what they call it. The feel of the times. So if you have that, therefore, when Part 4 came to be enacted, we had all the history of post-French Revolution, liberty, equality, fraternity, and then the Marxist traditions, then the Fabian socialism, utopian socialism, so on and so forth. So that's why Oscar Wilde said beautifully about a map of the world which does not have an utopianism is not a world to land at all. The soul of man without socialism and all that kind of stuff. So we have an idea of landing somewhere. But how do we land somewhere? Therefore, nobody could have probably said Part 4 is a perfect kind of a blueprint where we can land what this nation wanted to land. Nor one could have said Part 4 is a complete antithesis of either Part 3 and Part 4. But then that's how it began. Our constitutional history began with Part 3 becoming a complete antithesis to Part 4. It's in that context when the state has to grapple with solutions, ideas, and responses. So we have all these very important developments in the Constitution. So while we certainly at the 31C at a later point of time, so we needed to probably erect a wall of support within the Constitution, while probably it could have been raised too high or raised too low is a different question. That's why we talk about basic structure. So there has to be a wall of support for many of the endeavors under Part 4 of the Constitution. So we see 31A, B, C only from that point of view. I'll address it a little later. Therefore, we look at 39B. Well, the Attorney General in minimum will say 38 is the bedrock of Part 4, etc., which is not probably accepted. But in a way, how do you draw up a roadmap for a better world? So if Part 3, if I can put it like this, is a provision for a saner and open society, but Part 4 is a roadmap for a better world.
So if a roadmap for a better world, then every step which the state can take in a roadmap for a better world will always get interlocked with this an open society having everybody claiming certain rights, interests, etc. Therefore, unless we have that understanding, so we are not, Chief Justice said, we are not looking at Constitution as a mere statute. To look a dictionary on the one hand and read constitutional provision on the other hand and try to give meanings, etc. It don't happen like that. So when you use transformative constitution, it's also for the court, for the citizen, and also for the state. So it takes therefore a combination of all these three players in the society to idealize and to go forward in this mission. So I thought it's important for us. It may be taking coal to Newcastle, but I thought we'll break this little preamble statements in order to understand 39B. If your lordship can pick up my note, it is 2F. And well, the Constitution will certainly be
Correct?
And when Justice Holmes said in that Lochner versus 2F, your lordships.
Four horsemen. Four horsemen versus three musketeers.
Two F, two F.
2F.
First paragraph is Article 39.
Revise.
Revive. Why?
Some advice.
Oh, no.
Yes, sir.
The first sentence is Article 39, right?
Yes. Yes, that's what I'm doing.
Yeah, Article 39 of the Constitution. That's right.
Fusion, yeah.
As we are talking about saying the Constitution is not treated like a why?
This 5 pages, yeah.
8 page.
Lordship, it may be called 2F revised. We
That
don't.
also has 4 pages.
8 page, right?
7 pages.
There's some 2F, right?
2F amendment.
7 pages.
2F.
Where is that? Not there?
With this, it's 8.
Huh? I hope your lordship has that.
We have 4 pages now.
It's about 78 pages. Including the cover page is 8 pages.
Your original 5 pages, do they remain on the statute book? Are they effaced?
Maybe they will not remain on the statute book.
Are they unenforceable? Are they substituted, effaced from the statute?
Maybe I will have the liberty to keep on revising them from time to time.
Yes, Article 39.
That is like to be or not to be the question.
One is the legislative exercise,
Yes,
one is the court exercise,
yes.
and now we are confronted with the Attorney General exercise.
Which will also consider a forensic exercise.
Yes.
Just saying, he talked about constitution expressions are not to be treated like common statutes. I thought one more statement. Well, certainly court in the context of a transformative constitution says, I'll have meanings to Article 21. But I want to say that while adding or giving meanings to certain expressions or words of the constitution is different from adding concepts and categories which may essentially fall in social, economic, or political realm. Giving meanings is one thing. Right to life includes livelihood. A telegraph includes telephone. But when you talk of concepts and categories which fall in social, economic, and political realm, court will be very ordinarily reluctant to treat them as meanings to be added into the constitution. I'll make good this submission little later. So when you talk about what is a resource, what's a material resource, what's a common good, etc., we will definitely have to pick up several social, economic, and political concepts and categories and thoughts. The common good is not something which you can go to a dictionary and find a meaning. Like when the UN declaration on new economic policy came, there was a lot of sociological literature on what is common good versus public good. Therefore, we have to probably travel into those areas where social, economic, and political concepts and ideas have a certain freemingling way. So I was trying to find out whether the court will be a little slow in bringing those ideas into this or taking them out of 39B or the directive from state policy, as the case may be, like when we do in the context of ordinary statutes. Now let me read this. Article 39 of the Constitution of India, and in particular, 39 clauses B and C are best understood as a combination of social, economic, and political principles. The organization of human life involves the organization of our activities, transactions, and our interactions with the physical world for the purpose of sustenance and welfare. All of the above can happen with the world of resources available both in natural state and made available by human interaction. So all things in the material world which are available and made available by human interaction or engagement constitute the resource of the community. That's a very broad statement, I think relevant for the purpose of understanding 39B and also 39C. Then how do we understand the following? Resources. Anything or object in the material physical world that human beings can use, exploit for human consumption or use, as also anything or object that can be made or created for any human purposes, will all constitute resources of the community. It's because that both resources available in nature and resources made by human interaction are of utility, value, and relevant for human purposes that Article 39B has in mind ownership and control. That's the reason. Material.
So therefore,
Fulfillment
private
of
property, in your definition, there is no concept of a private ownership at all.
it talks about all resources. That's why Ranganath Reddy said man-made plus natural. He did not go into a private ownership. He talked about only this distinction. Natural versus man-made.
But it has to be a material resource of the community.
Yes, yes. I'll try to address that question. Because after all, we live in a material world. All resources which we use and create are all material resources.
But they may not be material resources of the community.
I'll come.
Your formulation.
I'll just come.
Anything which is created by the application of private labor is a material resource of the community.
They are material resources, but they're community resources with a different issue altogether.
No, because you said
I'll just come to that. Allow me to
Because you have said that, you have said of the community, thus all things in the material world. which
We are not trying to
available
address it. What are a material resource?
and made available by human interaction or engagement constitute the resources of the community.
That's right. I'll try to make good that as I go further. So material fulfillment of
The house using my own income, that's
Yeah.
a material resource of the community.
no.
Or if I own a car, that's a material resource of the community.
What I create, I make for myself, for my own personal consumption.
What I
It
earn
doesn't
by
go.
way of a
It doesn't
salary.
transcend. It doesn't transcend beyond a certain limit or a boundary.
What I earn by way of a salary by the.
That's true. It can. That's in a given case. Therefore, what I create, if it doesn't go beyond a certain boundary, it may remain my private resource only for my human consumption. But the moment it goes beyond the boundary, then it becomes there is an element of the community having a call on that resource. Community will have a call on that resource.
Only the taxes which will
That's
be
why transportation service. Transportation service.
But
I want to, so that for a little broad, we can come back to it. I want put that broad canvas so that we understand where we probably land.
will we be
Yes.
sort of treading the right path by divorcing your definition that you are giving from the word community? After all, community has a connotation. And you are saying that whatever the human resources is capable of generating can also fall into the ambit of community. That becomes a little difficult. The government can tax, certainly suppose somebody is earning an X amount, so much tax. Y amount, so much tax. But then it becomes resources of the community.
As I develop it further, I think a little more clear. What I'm trying to say is, we don't live, as the poet, English poet John, we don't live in isolation. All of us live in transactions, interrelationships. So the wealth we create, the value we create, are all by our interactions in economic activities. So the word resource in 39B essentially connotes an economic base. It has to be understood from that framework. So if we are talking about wealth, value created by human interactions, and as long as it remains, for instance, I dig, yes.
That means the corporation which produces cars, or a corporation which produces semiconductor chips, corporation which produces mobile, all these are resources of the
They
community.
are all resources of the community.
Material resources of the community.
They are all resources of the community, in the most fundamental constitutional sense. The next question is whether, to what extent state can enter into regulating, etc., is a different question altogether. That's where we land probably into scanning of the state's control, state's regulation, prohibition, restriction, to what extent, degree, all that questions will come later. But if we look at resources as a very narrow area, that's why I thought the referral order talks about private versus public resources. Perhaps that's not what Ranganath Reddy was talking about. When it said man-made resources, it all meant resources which are in private hands. Capital, share values, they're all resources.
That probably capacity to raise loan was also mentioned. And if somebody can raise a loan also, that is also the material resource.
Yeah, I want to lay a foundation that I know there'll be all questions about why do we have a very broad canvas about a resource. I understand that, but I thought let me place that and then try to find out where we are able to navigate further. May read it and then come back to this resources concept once again. So we're looking at material. Fulfillment of human sustenance needs and other connected purposes happen through human interaction with the material world. Non-material resources of the community are not contemplated in Article 39B. For example, culture or literature or non-material resources. This distinction is sufficient to understand the use of the word material. So that's why where I create something for myself, a piece of poetry or literature, a culture, where a way of living. So it doesn't enter into a state's domain to own and control. But anything else besides that are the material resources of the community. So in the early days of the socialist thought and the Fabian utopian socialist thought, etc., they looked at land, factories. You go back in point of time, 18th and 19th century, the textile mills in England, or what Maxim Gorky talked about in his book Mother. So it's all about that narrow resources which were in that at that point of time. But they still included both private and public resources. But as we moved into further what's called enhanced understanding of the economic role that a state need to play in the ownership and control of all resources, I think today, regardless of the fact that we have moved away from a very given up notion of the socialist controlled model, regardless of all that, the need or a necessity for the state at any point of time to take stock of the resources of the community for subserving the common good will always be an open question. So therefore, it's important for us to understand why, along with the moving times, if we give certain or contemporary meanings to these expressions, then we would have served the constitutional purpose of ensuring that 39B and C play their role well. The moment we try to cap and confine Article 39B, saying that concern only with land or mineral resources, etc., then we are probably missing the most important message under Article 39B as it must evolve with the times. So therefore, the only way I thought one could look at it is the distinction between material and non-material. What is non-material is certainly not within the ownership and control. And what is non-material, we can have many examples like this. So as I said, it is not exactly a dictionary definition. We have to look at the social and economic history of how all these ideas evolved over a period of time. So we must land there and then to probably able to have an understanding of why Constitution captured it, probably with certain base or inspirations at a given point of time. But as I say, we must also infuse in this meaning which will keep the Constitution alive. So let me take to the next part of it, common good and distribution. The words common and community must be read together. Community connotes a set of people adhering to an organized way of life in a given locality, and it would also include a section or part of it. Again, you go back to sociology, community has so many connotations, urban community, rural community, or a community with reference to a particular faith. We're not talking about that. So community can be a nation, community can be a part of a nation, community. Therefore, the geographical area where people have an organized way of life is a community in the large sociological understanding of this term. And the word community, even before the 1900s, been used in several senses, but the most important sense, like the sociologist Max Weber was talking about, it is a set of people living in an organized locality and sharing certain values, would like to interact and live as part of a clan of people, a group of people. Therefore, the word community will have to be given that kind of an understanding. So at a time when economic scarcity was to be dealt with, control of trade and commerce in several essential commodities were all for the common good of the entire community. at a time when economic scarcity was to be dealt with, control of trade and commerce in several essential commodities were all for the common good of the entire community. Cement was a controlled industry, like gold used to be earlier. In the context of this case, the housing needs of a particular section of the people is the common good of that section. The housing needs of a particular section is the common good of that section. Distribution can mean spreading, which suggests equal allocation of resources in favor of the defined class of persons on the entitlement of common good. If we then see why ownership and control will come in, understanding of ownership under the legal thought is well known. It includes matters such as title, matters such as absolute discretion of the use of property or a resource. Control includes elements of regulation and can extend up to prohibition. The meaning of the word restriction in Article 19(2), as expounded by the court, suggests the latitude of choices available within the scope of restriction or control. So that is probably the larger view of looking at 39B and C. If you have that in mind, then as I proceed a little further, if you look at paragraph 4, the object of Article 39B is the realization of common good by recourse to the resources of the community. To the extent such resources are under the ownership or control of citizens, the state is called upon to explore the common good and for that purpose deal with the ownership and control of resources in the hands of citizens. Once resources are in the hands of the state, no further questions about ownership and control issues will make sense. The reference to private resources in the order of reference, Honorable Court, may properly be read as a reference to human-made resources. That's what Ranganatha Reddy has in mind. So Article 39 is in the company of directive principles of state policy. It has enacted principles of social, economic, and political equality and the realization of an egalitarian social order. In Kasturilal, this court, Honorable Court has held, I read, it was pointed out by this court in Ramanadayaram Shetty that with the growth of welfare state, new forms of property in the shape of government largesse are developing, since the government is increasingly assuming the role of regulator and dispenser of social services and provider of a large number of benefits, including jobs, contract, licenses, quotas, mineral rights, etc. There is increasing expansion of the magnitude and range of governmental functions as we move closer to the welfare state, and the result is that more and more of our wealth consists of these new forms of property. Some of these forms of wealth may be in the nature of legal right, but the large majority of them are the nature of privileges. Therefore, today we're talking of a very expanded understanding of new forms of property. Banking, insurance, the whole technology in several services, they're all new forms of property. And most of them are in the service of the community. So you snap good part of a technology and economy today, I think the whole organization of social life will collapse. So much of our economic activity depends on how do we harness human interaction, producing economic wealth and for the common good. While we will certainly the regulation and control, how we do it is a different question. So also the concept of public interest must be, as far as possible, receive its orientation from the directive principle. But according to the founding fathers constitutes the plainest requirement of public interest set out as the directive principle, and they embody par excellence the constitutional concept of public interest. If therefore any governmental action is calculated to implement or give effect to a directive principle, it would ordinarily, subject to any other overriding consideration, be informed with public interest. That's one shade of common good. Then directive principles of state policy and fundamental rights are the two wheels of the same chariot. Please see so and so. I will skip these two paragraphs for the time being. I will come to para 8. As I come back to Minerva Mills, I'll read paras 56, etc. Then paragraph 8, in Lochner versus New York, Holmes, with his dissenting note, had observed as follows. But a constitution is not intended to embody a particular economic theory, whether of paternalism and the organic relation of citizen to the state or of laissez-faire, is made for people of fundamentally differing views, and the accident of finding certain opinions natural and familiar or novel, and even shocking ought not to conclude our judgment upon the question whether statutes embodying them conflict with the Constitution of the United States. That's why we're talking about the Constitution being read in more than one sense and in an enlarged sense wherever the demands require. Now, paragraph 9. Having regard to the constitutional context in which Article 39B is located and its relevance towards realization of an egalitarian social order, any narrow or truncated reading of the provision may itself be offensive to the free play that is desirable in the working of the principle enshrined in Article 39. There is nothing in Article 39 which suggests of any limitation or qualification of the words used therein. The distinction between public or private resources or natural versus human-made resources is alien to the spirit of Article 39B and C. That's why I said we will not read into the Article 39 any economic, political, other categories or concepts which are not themselves found in Article 39B and C. Article 13B and C could not probably otherwise word it. They tried to convey a whole range of aspirations and principles of building an egalitarian social order. So it's not like drawing a statute. 39B and C is not like drawing a statute for a working purpose. So therefore I started saying that unless we have in mind the whole historical background which led to the formulation of these ideas and principles, they have to be treated as signposts. And the signpost may not be said, I'll cross a line here on signpost. Then you will never understand the signpost. So a cursory glance of cases decided by the Honorable Court with reference to Article 39B provides us an insight on the range of resources which have come up for consideration. For instance, in Banerjee versus Anita Pan, it's a case of freezing on suit for eviction by transferee landlord for 3 years. Then the next, I skipped Ranganatha Reddy, serial number 2, and 3, Bhim Singh Ji is about land, Sanjeev 4 is about coke oven plant, which is then a processed mineral. Then serial number 5, Abu Kawar deals with a whole range of issues, but particularly stage carriage and contract carriage, which is on par with Ranganatha Reddy. Then 6, National Textile Corporation, assets of 6 textile undertakings, mills and industries. And they are obviously private properties and private resources. In Union of India West Cyanamide, it's a case of regulating drugs, pharmaceutical industry. In item 8, serial number 8, it's a case of regulating electricity as an industry. A constitution bench. Then Pathasarathi, serial number 9, where a company is issuing shares, Capital Control Authority were to regulate the share market. So shares as resource of the community. Then Orient Paper Industries. So you have a forest, you give a license to cut bamboos and then make them as a forest industry. And then 11, a refractory plant, again an industry, which is a true industry in the economic sense. Then item 12, we look at grant of dealerships of petroleum products. So it's a public resource, equality, to bring about equality in accessing public resources. So look at a wide range of resources which have to necessarily come within the ambit of distribution for common good. Then 13, land, 14 is about mines and minerals, 15 is again about a mining lease. So the whole law of mines have undergone a sea change now. And you still say auction or otherwise to allocate material resources to the community. Then Mafatlal, with a case of refund of excise duty, where they pressed into service 39D, I'll show all those judgments. Then 17, is natural gas. 18 is again a question of grant of natural resource. Then Coal India, recent judgment where Nagaratna was there. Then application of the Competition Act to nationalize coal companies. So how competition element is important even among public sector undertaking. 39, we was brought into picture and it was discussed there. So I just gave a few illustrations to show that how the resources of the community will have to be understood from a very large framework of what will serve both individual, sectional, or collective good of the community. So sometimes it can be an individual need in the disabled part of a community. So may require a certain technology improvement to serve them. So there has to be financial incentives. Which company will do that? I mean, regulate it. Therefore, the regulation and ownership and control will subserve not only the, when they talk of common good, it's not necessarily the entire national good. It can be the good of a certain section, an identified section of the community. And that's a state obligation. Where is this? The other submission? Earlier one. Turn to volume 2. No, should not read this. I'm sorry,
Please wait.
Volume.
volume 2. Which one you want me to? Yes, I read it. What we have done here, yeah, the shorter one was just like a paraphrased one. This is a detailed one. I also appear for MADA, therefore it is done keeping that in mind.
Yes.
Yes. What I've done here is each paragraph, I'm sorry,
Page 38.
page 38. I'll quickly, each paragraph refers to some judgment or the other to catch the, let's call the wide meaning of resources which our courts have dealt with earlier already. For instance, in para 13 at page para 12, the idea of distribution of the idea of distribution of material resources of the community as prescribed under Article 39B is not necessarily limited to the idea of what is taken over for the distribution among the intended beneficiaries. I'll read each one of them a little later, just giving a broad overview. In para 13, the theme of the amended provision of the MHID Act advances the social cause of the homeless families and the provisions contained therein can easily be classified as a socially beneficial statute. The courts on various occasions have expressed the reservation in striking down a socially beneficial statute dead unless a plain breach of the fundamental rights citizen is manifest. That's what Anita Pan says. That's just Anita Pan just before in Ranganatha Reddy. It just preceded Ranganatha Reddy. Para 14, courts have to ensure the directive principles are not to be dismissed with a master teasing illusion and a promise of unreality, curtailment in public interest of such extreme rights of the landlord as are read in tooth and claw is a constitutional compulsion. Then I'll skip Ranganatha Reddy for the time being to come back to it later. Let's just turn to page 40, para 19. That's a statement from Beam Singh. There's a wide misconception that only the public utilities can subserve the common good and fulfill the objective of common good. It shall not be an understatement to aver that even a private resource may be for a national need and serve the common good. Article 39B of the Constitution should be construed in the light of Article 38 and understood as placing an affirmative obligation upon the state to ensure the distribution of material resources does not result in heightening inequalities among people and among regions. Then Article 39B envisages state shall in particular direct policy towards securing ownership and control are so distributed as to observe the common good. Socio-economic justice read the arc of the Constitution. Public resources distributed to achieve that objective since liberty and meaningful right of life or age with availability of opportunities and resources to augment economic empowerment. We just look at it like that, and how are opportunities created in the social world? It's not merely an opportunity for an employment in the public sector. So opportunities created by economic transaction, economic activities. So unless you have enough opportunities and equal opportunities, even outside the realm of the state, and that's where the ownership and control made itself. So the common good principle comes in. So mandate of Article 39B does not impose a restriction on the means adopted to subserve the public good and uses the word distribution, suggesting that the methodology of distribution is not fixed. So when natural resources are made available by the state to private persons for commercial exploitation exclusively for their individual gains, the state's endeavor must be towards maximization of revenue. This alone would ensure fundamental rights in Article 14 and directive principles in Article 39B are extended to the citizen of the country. Then, in Jijubai, each word in Article 39 has a strategic role, and the whole article has a social mission. as a strategic role,
Yes.
that page, yes, yes. Each word in Article 39 has a strategic role, and the whole of article has a social mission. It embraces the entire material resources of the community. Its task is to distribute the resources. Its goal is to undertake distribution as best of the common good. It recognizes with the distribution the ownership and control of so-and-so. Term resource is a sweeping expression and covers not only cash resources, but even ability to borrow credit resources. Each one's judgments add on to a certain, facet to the understanding of resources. The word distribution used in Article 39B must be broadly construed so that a court may give full and comprehensive effect to the statutory intent contained in 39B. It should not be construed in a purely literal sense.
Mr. Attorney, come straight to para 27 of your written submissions. That's what
27, you got it?
That's exactly what you want to convey. Where you have referred to Jijubai.
Yes.
Just come to that.
I'll read that.
And then you can conclude.
The material resource of the community is a wide concept, broadly interpreted to bring within sweep all resources, natural or physical, movable, immovable, corporeal or incorporeal, tangible or intangible properties, etc. Private resources or property are part of the material resource of the community. All things that produce wealth for the community. Why is it stated to be so widely, sweepingly made? Oh, as I've been trying to understand today, I think every little part of our life on an organized basis takes place by reason of wide range of economic activities coming together. So when you say all that produce wealth, when you talk of wealth, for instance, in the early part of the 18th and 19th century, we talked about the wealth which is available as part of a land or a wealth you have produced and put it in a bank. Wealth today has no such, minimal connotation. So it has, that's why we talk of different forms of property. Today we talk of emerging forms of property. So wealth must be understood in that sense, not merely monetary wealth.
Legal rights, correct?
And sorry.
Wealth would be in the nature of legal rights. The large majority of them are in the nature of privileges. We are just putting it to you.
No. Let me complete reading this because I thought while this was a very engaging issue in the sense that you don't have a very pedestrian answer to it. You can't say, well, private resources are exempted from 39B, but then we don't answer the question, what are those private resources? How do they come about? Therefore, in Jijubai, they look at the larger way of understanding. Yes.
To go into these issues at this point of time.
We can. I'm trying to, why that we need to go into it is to say that 31C has lost its relevance in the sense that we are an open society, a free economy. We're not talking about a very outmoded Marxist notion of distribution level. I don't think the court should look at it in that perspective. In the economic history of a country, we still have large mass of population who need to be brought succor to their life. So it's from that point of view, 39 was enacted, and we still have not traveled a good part of the journey. Therefore, to say that it has now lost its Marxist connotation, I think would be to look at only Marxism and leave everything else outside of understanding. If that is the way, probably then China would not have probably taken this course of regulated capitalism. So therefore, it's important for us to say that we will not halt or the arrest the progress of certain part of our constitution and leaving it in the responsible hands of the state to regulate the ownership and control of the resources, to subserve the common good. Each one of them in a given context or a statutory context will be certainly scrutinized. There will be certainly a judicial review of whether does it serve a particular common good or a public good, or it's an illusory, common we're talking about.
That's the core issue.
That's right. That certainly will happen. That tool is available in the hands of the court. But to say that, no, we will try to give a very narrow meaning to 39B and to curtail its broadest expansive understanding and the potential of its use in the hands of the state.
Yes.
In Jijubai, in that paragraph, they talk about providing access to equal opportunity. That's why, for instance, we have in the New Deal era in the 1930s, the Lochner era they call it. So provision of economic opportunities for the racially segregated. So the US Supreme Court should deal with them. So equal opportunity in the economic field. So accessing banking resources. So a wide range of resources today are evolving. So access to those who must act, for those people who are not able to access them on their own. So when Amartya Sen talked about the capabilities approach, he looked at a world where it can be probably brought by certain amount of state involvement in it. So unless I have the capabilities built with me, which can happen only if I have access to resources. So if I don't have access to a human housing resource, so what did Olga Tallis talk about? So if so you take away my life and therefore you take away my means of life, I take away my life. Shylock talking about in Merchant of Venice. So access to many things in life today depend upon how they can be made available by voluntary economic engagements and by state engagement. So the facilitating, the enabling environment can be built only when you have a certain understanding. But that does not mean the state can lay it very broadly, can lay it arbitrarily. That's a different area altogether.